A second, and then I may pause it and ask you a few questions.
Okay.
Eric, you might
Yes, sir.
keep the lights turned down.
Yes, Anthony, if we could turn the lights down just a little bit. Can you get one more? If not, it's... Okay. What exactly are we viewing here, Officer Reno?
This is the back of the apartment building itself. And because we didn't have any good cover, we're just kind of on a hill.
What are you doing in this photo with your gun, your light? Can you just describe the scene for us, what you're personally doing?
This point, I guess I don't know why we don't have the audio, but I believe at this point we see the broken glass, so I'm using the weapon-mounted light on my rifle to attempt to illuminate the area. I was, and I still am, unfamiliar with the layout of this apartment complex, so I believed at the time that that back glass led to the target apartment. So that's what I'm observing and covering.
At some point, do you ever see anyone come out of that apartment, expose themselves? What do you see?
Yes, at some point there was what I believed to be a shirtless white gentleman that kind of just showed himself from that broken window, at which point I hail him, tell him to show me his hands. He shows them for a second and then ducks back into the apartment for the remainder.
At that time, did you believe he to be the suspect?
I believed him to be related in some way. I mean, we came onto the scene with limited information, so I didn't know what the suspect was supposed to look like or what the target even was.
Your Honor, I'm going to pause this and see if we can get the audio to work. approximately do you hold this position back on the back of the residence?
I don't remember how long we were out there, but from the time I got there and till the time we left, that was the only position I held on the apartment.
Okay. At some point, do you all approach the residence at all?
Yes. I guess we'll see it here in a moment. After, I believe it to be after the SWAT team cleared the actual target apartment and told us that no one was inside, we approached the broken glass.
Was that the first indication that you had that this apartment was in fact not a threat to you?
Yes.
I'm going to move the clip forward just. In a second, I'm going to have you describe what we see when you begin to move. When you were in this position right here, there's other officers you testified about. Are there any, is a canine officer there? Who else was there with you?
I know there was a canine officer. He would have been to my right. Aside from that, I know there were other officers. I don't know an exact number, nor do I know who they were because they weren't my direct partners that I usually work with.
Okay. Is this dog a narcotics type dog or patrol type dog?
I believe him to be a patrol dog, but I'm not canine, nor do I know what dog it was.
Okay. Who gives you all the actual order to move up here?
I don't know that anyone gave us an order to move up to the...
So it was only SWAT that was able to indicate that they had cleared that you moved up.
If I recall correctly. Yes.
What do you see when you get to this point?
There's the glass door that's broken. That's all I was able to see. I didn't see anyone else at this point. Whoever was in there had retreated further back into the apartment.
What do you do next here as we see you walk away?
At that point, I believe I went up to the front for maybe a minute to find my partner, and then I went back to my car to go back to the First Division.
Okay. And then after returning from that part of the portion of the apartment complex and returning to your partner, did you have any further involvement in the scene at all?
No,
You did not re-enter the scene?
no.
Those that were out back, not the canine, those officers that were out back, did they all have rifles with them?
Not all of them. I know there was probably a mix. I don't remember.
Were they all armed?
Yes, we're all armed police officers.
Okay. And when you were armed, you're pointing it at what you assessed at the time to be that apartment who you thought was the target at the time?
I was, yes.
I think those are all the questions I have for you, Officer Renaud. Thank you.
Cross-examination?
Thank you, Your Honor. Officer Renaud, when you first arrived on Springfield, you testified there was a gate.
Yes.
You remember what the condition of that gate was?
I remember that it was run through with a car. There was a light bar laying on the ground. I actually remember the radio traffic of somebody telling an officer to ram the gate.
Do you know who told the officer to ram the gate?
I do not.
When you arrived, you proceeded through the gate and went up to 3003 Springfield, correct? Or up to the area of the apartment that was at issue?
Yes, sir.
And you got out of your police cruiser and you testified you went around the back, correct?
My police cruiser was actually probably a quarter mile back on whatever that main road is. I couldn't tell you which road it is, but
Oh, is that because there were so many police cruisers on Springfield? So you walked up through the gate, correct?
that's correct.
Okay, and why did you had your rifle with you at that time?
Yes, sir.
Why did you have your rifle?
Better shooting platform and has a better flashlight than my pistol does. It's dark.
Had you been told to bring a rifle?
Not that I can recall, but somebody had just shot at police officers. So,
And so you proceeded around the back of the apartment building, correct?
yes, sir.
And why did you go around the back?
I was trying to find a helpful spot to be. I was just looking for work. The front had a lot of officers.
Okay, nobody told you to go around and cover the back?
Not that I recall.
Okay, and you testified that when you went around the back, you saw a window or a glass door with multiple bullet holes, correct?
Yes.
Were there multiple bullet holes or was it simply broken glass?
I guess what I could see is simply broken glass.
Okay, you don't know how that glass broke, correct?
That's correct.
And it was your impression at that time that that apartment was part of the apartment that was being searched in the front, is that right?
That was my impression at the time. Yes, sir.
And you indicated that you took up your position and you kept your rifle pointed at that broken door throughout that video we just saw, correct?
Yes, sir.
And why was that?
I believed it was possible there was a threat still inside the apartment.
And you later learned that the apartment was not part of the original situation, correct?
That's correct.
Could you see that apartment from the front of the building?
I'm not sure.
I don't have anything further, thank you.
Anything on redirect? You can step down, thank you.
Thank you, ma'am.
The Commonwealth's next witness? You may. All right, ladies and gentlemen, this will be a good time for us to go ahead and take the lunch break. So we will be in recess until 1:15, and please remember the separation admonition, and I will see you back then.
All rise for the recording jury.
10:30, officer down. 10:30, Officer Sean Springfield.
What's the location?
Officer Sean Springfield, 10:30. Eyes EMS. EMS is around the corner, radio. We need EMS fucking up here now.
I'm getting him started.
Already down the street. Tell him to get up here.
Right, okay, use the start to Springfield Drive. We have EMS in the way.
1 David on Springfield. Where y'all at?
3007 Springfield Drive.
Do not block EMS. Ram that gate. Ram that gate, patrol car. Ram that gate. Patrol, ram that fucking gate now. Ram it with your car. Ram it.
Here, quick cut. Here. We're gonna cut him. Here. Cut it with my knife. You okay, John? John, you okay? Huh? Hey, fuck this EMS, dude. Somebody give me the radio with SWAT on it. SWAT 1. Here.
Officers encountered rifle fire. Officer down. Bring long guns. Subject is still inside, radio, barricaded with a long rifle. Looks like an AR.
Subject still inside, barricaded with an AR.
Be advised.
He is still inside. We've got cover on the door. We don't know if there's a back door to this place.
Looks like an upstairs apartment. Upstairs apartment. Text your family. Hey, upstairs apartment. You want me to get in the turret? Cover high? Yes. What'd you say, Sarge? Text your family. And upstairs. I think it's an upstairs apartment. Then I'll pull up and we get you fucking through. Now, what if it's my phone? Okay. Person apartment number 4, building 303. Apartment number 4. Please come out with your hands up. You have to talk louder. I cannot hear you. Keep your fucking hands up. Coming out. Step to your right, 2 steps. To your right, 2 steps. Now step down on the step and keep walking backwards. Step down, and I want you to walk between these cars. Walk straight down the steps or backwards. Keep walking backwards. 1 more step, sir. Now I need you to walk back between these 2 vehicles. Keep walking backwards. You're almost doing it. You're doing a great job. Yeah. Keep walking. Do not do anything else. Do not reach down. We'll get him right here. Right here. Keep coming back, sir. Keep coming back, sir. Keep walking backward. You're scared. Right. Walk straight back, or I'll send this dog on you. Walk back to my boy. Walk back, or I'll send this dog. Walk back to me. Keep on walking. Walk down. Walk. Walk back to me. Let's get behind this car for cover. What did I do? Who else is in the apartment? Nobody. My girlfriend's dead. Tell them we have 1 10 15. Where? How's your girlfriend? I don't know. Inside? Yeah, somebody. When I was banging at the door, she said, "Who is it?" And I just started shooting.
No, we down 3 times.
This pocket's clear. There's somebody in there dead?
Yeah, my girlfriend. It's her house. That was her house.
We have to go in if there's somebody.
What is this about? We don't.
I'm with you if you want to go.
We're both just regular worker people.
Where is she at in the apartment?
She's on the ground.
Where at?
In the hallway.
What kind of gun did she shoot?
It's a regular 9mm.
Did she shoot or you shoot it?
It was her. She was scared. We didn't even know who it was. We didn't know who it was. We was in the bed.
Got you.
We was in the bed. We didn't know who it was. The gun's legal, like, and everything. We don't even know who it was.
I don't know who it is.
She asked 10 times.
We don't know whose it is.
Yes.
Hang on.
Here comes the fence. Hey, heads up. Stay back a little bit.
Is Joe good?
Everybody okay?
Yeah.
You all right, Joe?
Watch out. Watch the door. Watch the door roll. Front door.
Hey, I'm throwing it to the front door. Hey, you're not gonna get over that lip. We're gonna have to go up there.
All right, that's fine. Give him one.
What do I mean?
What do you need, Hogan?
Cover her. Oh, sorry. Give me another body.
I'm here.
Hold on. We're going to stay here, Zoo. Go with the Sarge and clear that good room to the right. And he's posted.
One on me!
I got you.
Hold on. I got her.
One on me.
I'm here.
I got him.
Fighting this door, too.
Hang on.
Hang on. Yeah. Can you cover her?
Hang on a second. Baker, out of that room.
I'm good right now. Good.
Cover from the other side. We got a bathroom that sucks back.
Hold on, Mike. All right.
Closet immediately left.
You got two closets that folding doors.
All right.
To your left and an open bathroom. Looks to be mostly clear. I'm up. I'm down here.
Oh, I can see he's clear. Hogan.
Yep. Clear.
You ready?
Yeah. Let's get this bed real quick. Get this bed. Slip in our bed real quick.
Hang on, let's check the bed.
Go ahead, man.
Have them pop that door. Is anybody right there to your left?
No. I'll come to it.
We still got to check the bed.
Check her. We got to check her. Check her. Make sure she's good.
Hey, lift the bed up. I'm going to go this way with my pistol or rifle.
Yeah, go ahead and get EMS in here.
Clear.
You can roll it over. Joe. There you go, buddy. Ma'am, can you hear us? Louisville Metro Police Department.
Check that wrist, dude. Check the wrist.
Medic up. Scene secure. She's 1080. We're leaving a couple people in here to hold the scene. It's secure for detectives to come up. So I think it's casing right there. Sorry. Right there. You're all's casings. They're casing. So,
Oh, that's their gun. Right here.
yeah, I'm right there.
That's theirs.
No, that's ours. It looks like theirs is in there. But I'd back out until they get PIU in here. So.
I see that there any guns visible.
We did not see any.
Is there any windows that go out that way?
The only casings look like 9 mils.
He said she was shooting, the suspect said that his girlfriend was shooting the ass with a 9mm.
Hey, this room right here, there's a pistol underneath the bed.
I'm not worried about that right now.
No, I know.
You know what I mean?
So, let it jab.
It's a crime scene.
Let it jab.
Do not walk by yourself. This is our city. This is our town.
For months in Kentucky, residents outraged by the killing of Breonna Taylor campaigned for the police officers who shot her to face charges.
Commonwealth of Kentucky versus Brett Hankison.
In September, a grand jury investigation indicted one officer for shooting into a neighbouring apartment and no one for killing Taylor.
Is that the decision of the grand jury? I will grant the motion and assign bond in the amount of $15,000 full cash and issue a warrant.
Is that it? Is that the only charge? What about the other? It can't be it. It can't be it.
No one has been held accountable. This is injustice, and this is a start clock for the next level of our protest.
What happened in the final minutes of Breonna Taylor's life? A full telling of that story has been impeded because none of the 7 police officers who raided her apartment used body cameras, a violation of police policy. But with the recent release of thousands of documents and images collected during 3 investigations, the Times initiated a fresh examination of the case. We used crime scene photos to create a precise model of Taylor's apartment. We forensically mapped out and retraced the first bullet fired by Taylor's boyfriend and the 32 bullets that police shot in return, through windows, walls and ceilings. Using interviews officers gave to investigators, we charted their movements as they carried out the raid. And we analysed hours of 911 calls, grand jury proceedings and footage of the SWAT team that arrived after the shooting.
Man, do you hear us?
Members of the grand jury have accused Kentucky's Attorney General, Daniel Cameron, of shielding the officers involved from homicide charges.
Our investigation found that Mattingly and Cosgrove were justified in their use of force.
Boom, 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 boom.
Sergeant Mattingly may have been justified in returning fire when he's fired upon, but our new analysis paints a more complicated picture about how this raid was compromised from beginning to end. We'll outline the flawed intelligence and tactical mistakes of a hodgepodge team of officers, their failure to properly announce their presence at Taylor's, the chaos and excessive use of force that ensued.
Okay, there's another hole right below the clock.
And we'll explore the damning analysis of an experienced SWAT commander who was called to the scene after the shooting.
We just got the feeling that night that something really bad happened.
The focus of the police investigation on March 13th is not Taylor's apartment, but properties 10 miles away in West Louisville.
Local Metro Police.
Hands behind your back, boss.
We're executing a search warrant. Come out.
Where dozens of SWAT and police officers arrest an ex-boyfriend of Taylor's and his associates and seize evidence including drugs. These officers are wearing their body cameras and they carry out the raid safely and without incident. What the SWAT team doesn't know is that at this time, a hastily assembled team of narcotics officers is about to raid Taylor's home across town. They suspect her ex-boyfriend keeps cash or drugs there, but their intel is poor. They don't know she has a new boyfriend and they think she lives alone. When 7 officers begin the raid at 12:40 a.m., they notice the lights are off, except for the flicker of a TV in a bedroom.
The light on the bedroom, the TV. I remember seeing it lit up blue when we pulled up.
Suggesting they know where Taylor is. In less than 3 minutes, she would be fatally shot. Inside, Taylor had dozed off while watching a movie with her boyfriend, Kenneth Walker. Adjacent is the bedroom of Taylor's sister, but she's not home. A hallway from the bedrooms leads to a living area, and the apartment's entrance is in this breezeway. The only light is this lamp opposite her door, where now the police begin to stack. In this reconstruction, we hear the official testimonies given by the 2 officers nearest the door, Mattingly and Nobles, Cosgrove, who's providing cover, and Hoover and Hankinson beside them. And we'll hear from neighbours and Kenneth Walker, who was interviewed by police right after the shooting.
When we all got up in line, I knocked on the door, banged on it.
Just as Mattingly begins to knock, a man emerges from the apartment directly above. He doesn't live there, but is picking up his child after finishing work.
The door right there, that's why the babysitter lives. So I came to pick up my little girl.
A squabble with Detective Brett Hankison ensues, and already the team seems on edge.
I remember Brett extending his gun saying, "Get back in your apartment, get back in your apartment." Brett was a little bit worked up. I remember looking at Brett saying, "Brett, relax. Brett, just relax, relax."
The man retreats inside. The police are supposed to be conducting a knock and announce raid, but that's not what Mattingly says happens at first.
We didn't announce the first couple because our intent was to give her plenty of time to come to the door.
Inside, Taylor wakes up.
So it's a loud bang at the door. She pops up out of her sleep. It scared her to death. Me too. Like, who is that?
Banged on the door, no response. Banged on it again, no response. At that point, we started announcing ourselves.
Whether the police announce themselves clearly enough is a critical issue in this story that we'll return to later on. Not knowing who's at the door this late, Walker grabs his licensed handgun.
Another knock at the door. She's like, who is it? Loud at the top of her lungs. No response. So I'm like, what the heck?
They rush to get dressed and walk toward the door.
We never even made it like mid-hallway. But as loud as we were screaming to say who it is, I know whoever would be on the other side of the door could hear us.
Outside, some of the police do hear Taylor.
I can hear somebody inside. I kept telling John, I can hear her.
But after knocking and waiting for around 45 seconds, they decided they've given her enough time to respond and rammed the door open.
The last time, I just said, let's just hit it. And that's when we did the, police search warrant.
We'll show here what the police and Walker describe seeing next.
And I hit it. After the third hit, it flew open. And that's when it hit the fan.
As we're coming to the door comes off the hinges like an explosion.
The officers now make a tactical mistake. Mattingly steps into the doorway and puts himself in what police describe as the fatal funnel, a position vulnerable to gunfire and hard to move from.
I could see down the hallway, and there's the male and a female, side by side, shoulder to shoulder, almost like they were together.
The apartment is lit only by the breezeway light that's coming from behind Mattingly and the faint glare of the TV in Taylor's bedroom.
You can't see anybody, though. It was dark. There was no lights.
Thinking it's an intruder, Walker aims low, shoots once, and hits Mattingly in the thigh.
I feel like I aimed down because I don't need to kill anybody. So I just let off one shot.
Mattingly immediately returns fire.
I got 4 rounds off, and it was like boom, 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 boom.
Then all of a sudden there's a whole lot of shots.
Mattingly fires 2 more rounds when he falls and takes cover. Almost at the same time, Cosgrove moves in and fires, stepping on Mattingly in the process. He has now also put himself in the fatal funnel, and although he's shooting, he appears to have no idea what's happening.
I see blinding, vivid, white light and blackness at the same time. I don't hear any gunfire at all, ever. And I did not have any pain sensation or any recollection that I'm firing.
He continues shooting blindly until he runs out of ammunition, a total of 16 rounds.
If you told me I didn't fire a gun, I'd be like, okay, I believe you.
In response to Walker's shot, Mattingly and Cosgrove together fire 4 shots into a chair, cupboards, and a stove in the kitchen. 2 bullets go into the ceiling and pass through the living room in the apartment above, where the man, his 2-year-old daughter, and babysitter waited. 3 more shots go into the living room wall to the right. And the officers fire 13 rounds down the hallway where Taylor and Walker stood. Taylor is shot 6 times on both sides of her body, in the abdomen and chest, her arm and leg, and twice in her foot. In all, these 2 officers fired 22 rounds in less than a minute. An FBI ballistics report found that both of them shot Taylor, and that one of the 16 rounds Cosgrove fired was the lethal bullet.
We both dropped to the ground, but I just hear her screaming, and
thinking they're under attack, some of the officers flee when they hear a pause in shooting.
There was a little bitty moment of no shots. I was like, here's the time to go, and then it all started up again.
We don't know the precise sequence of events, but Detective Hankison runs to the front.
I can hear the firing as I'm making the corner. I can see
the flashes, the muzzle flashes.
But the only ones shooting are police. Even though all the curtains are drawn, Hankison blindly fires 5 bullets through the patio windows.
My only option was to return fire, and I did that to the muzzle flashes.
He moves and fires 5 more rounds through the bedroom window of Taylor's sister, who isn't home. 2 bullets fly over Walker and Taylor, but none hits them. The bullets that go into the living area pass over Taylor's sofa and kitchen table and smash her clock. 3 penetrate the wall and enter her neighbour's apartment. Those bullets also smash the kitchen table, hit a wall, and shatter the patio doors at the rear. A pregnant woman, her son and partner were home. Hankison has been charged with wantonly endangering their lives. In total, the police fire 32 bullets, penetrating almost every room in Taylor's apartment. They hit saucepans, cereal boxes, and smash into her shower. They puncture shoes, shatter cleaning equipment, and land in her sister's clothing. And 3 minutes after police came to search her home, a fatally wounded Taylor is lying on the ground.
I'm just panicking and I'm telling somebody, I'm yelling help because she's right here bleeding and nobody's coming, and I'm just confused and scared, and I feel the same right now. That's it.
Months later, when Attorney General Daniel Cameron presented the charges against Hankison and said that Mattingly and Cosgrove's actions were justified, he emphasised that police did properly announce themselves.
Evidence shows that officers both knocked and announced their presence at the apartment.
But actually, the evidence is far from clear. In 911 calls immediately after the shooting, Taylor's neighbours don't know police are carrying out a raid.
Please get a police out here. They are shooting back. Something's going on next door, and there's bullet holes all the way through the wall, through our glass. I have a 5-year-old in here, so something needs to be explained to me.
And in statements police took afterwards, none of Taylor's neighbours heard the officers announce. This apartment's patio door was open.
I mean, I was completely unaware that it was cops.
2 teenagers in this apartment heard a commotion, but didn't hear police announce through their open window, their mom said.
They told me that nothing was said, that they just beat on the door. I said, so y'all don't know if it was them? She was like, they didn't say nothing, they just beat on the door.
And the family who lived directly above Taylor also heard nothing.
Before the gunshots come out, did you hear anything?
Conversations or anything like that, people talking? No.
In their statements and in interviews with The Times, over a dozen neighbours say they did not hear the police. Attorney General Cameron's assertion rests on the accounts of police officers and a single witness, Aaron Sarpy, the man collecting his daughter that night and who saw the police when he came outside. In his first interview with investigators, Sarpy was asked what he heard when he went back inside.
Did you ever hear anyone identify themselves as police?
No, nobody identified themselves.
Months later, he told police his memory was foggy, but that he thought officers did announce. And beyond what the police said, this critical grand jury conclusion rested on his entirely inconsistent account. After the raid, the scene outside is chaos. Officers tend to Mattingly, but an ambulance that had been staging nearby is nowhere to be found.
Fuck is EMS? They were 15 minutes away. Somebody give me the radio with SWAT on it.
They radio the SWAT officers across town.
EMS on Springfield.
Who are surprised by the call.
We're Springfield. They're requesting armor down there. We're going to go ahead and take it. Let's go, let's go, let's go.
They head for Taylor's address.
It's an apartment.
I didn't know they were in that tonight. I knew it was part of the investigation.
As SWAT arrives, close to 40 police vehicles are already at the scene. Around this time, Taylor's boyfriend, Kenneth Walker, is being arrested.
You've been hit by a bullet. That's unfortunate. Keep walking backwards. Hey, come on, we need to get moved because there might be a victim inside. Walk backwards. Keep walking backwards. You're scared, right? Walk back, I don't send this stuff. Walk back to me.
Walker had called 911 and neighbours had heard his pleas for help.
You're in a fucking prison, that's what's going on.
But at 1 a.m., almost 20 minutes after the shooting, the police still don't know Taylor is critically injured inside.
There's somebody in there dead? Yeah, my girlfriend. It's her house. We have to go in if there's somebody. Yeah. What is this about? My girlfriend is dead.
I don't get. Keep walking.
As Walker is being led out, SWAT gets ready to secure the apartment.
Hey, there's a kid upstairs. He's not. It's a kid upstairs, little kid.
What the? Hey, front door. Moving. Short. Clear.
Left side clear.
Go ahead and get EMS in here.
Check her pulse.
Only now, half an hour after the raid began, does an EMT finally check Taylor.
Yeah, there's a hole right there.
And later, as two officers stand guard, they take in the scene. They see Taylor's uniform. She worked as an emergency room technician in city hospitals. They note the bullet holes.
Body level.
Hey, can anybody advise if we talk to the neighbors directly above this apartment? There's gunshot holes in the ceiling.
Outside, the SWAT officers debrief on what they've seen.
Hey, camera's off there, Mike.
Yeah, mine's off. This is the fucking one that said that he has to do.
The SWAT commander who was called to Taylor's home after the raid was later interviewed by investigators.
We just got the feeling that night that something really bad happened.
Dale Massey, a 20-year police veteran, was highly critical of what unfolded. He said there was no coordination with SWAT.
We had no idea they were going to be at that apartment that night. I would have advised them 100% not to do it.
And that executing another warrant at the same time may have compromised Taylor's safety.
We treat safety very important, right? So like simultaneous warrants, bad business.
Narcotics officers testified that they didn't know Taylor had a new boyfriend, that her sister lived there, or that her 2-year-old goddaughter regularly stayed. Massey said the department had a history of poor intelligence gathering.
Back in the day, we would take a lot of detective information and take it as golden. Not anymore, because so often there's no kids, there's no dogs, we're told, there's kids and dogs. So we have an exhaustive recon process that we go through.
He said standing in the doorway, the fatal funnel, as Mattingly and Cosgrove had, was a tactical mistake.
Is it practical or is it even common for 3 people to be in what we consider the fatal funnel?
Absolutely not, no. You would never put, yourself in that situation.
And that there's a right way and a wrong way to conduct a raid. You knock, announce, and give people ample time to leave.
We're not going to rush in to get dope. We're not going to treat human life more important than any amount of dope, right?
And just to be clear, no drugs were ever found at Taylor's. His harshest criticism was of Hankison's blind shots into the apartment.
You have to know, A, what you're shooting at, B, what's in front of it, and B, what's behind it. There's no other way you can operate. It was just an egregious act.
Under Kentucky law, Kenneth Walker had a right to stand his ground against what he believed was an aggressor, and the police in turn have a right to self-defense. But in this analysis, the killing of Breonna Taylor resulted from poor planning compounded by reckless execution. Louisville has instituted police reforms, and Taylor's family received a substantial settlement, but the case isn't closed. Investigations and lawsuits are ongoing, and 9 months after Taylor was killed, her family is seeking a fresh inquiry into the officers involved.
Pages, I believe approximately 2 pages of the transcript that are relevant to the actual shooting, and another group of pages, approximately 10 pages, I believe, that are relevant to the issue of the neighbor upstairs or the visitor upstairs appearing on the landing. So that's what we would ask be those portions of the deposition that are relevant be used, not all 228 pages, most of which are not relevant.
All right, Mr. Matthews.
Well, Judge, with reference to the Mattingly deposition, I concur with what Ms. Whaley just stated. That deposition was kind of all over the place, and it devolved into some personal attacks back and forth between the witness and the questioning attorney. And I agree that it was it would be very difficult to redact that, and I think that's why we decided not to use it. On the other hand, with reference to Detective Cosgrove's deposition, and I don't believe the whole 228 pages is testimony. There's a lot of stuff at the end, but that is just citations to page numbers and so on. But the entire deposition is related to the events that occurred on March 13, 2020 at 3003 Springfield Drive, and I believe that it's all relevant. And I don't believe there's a whole lot of material in there that is not probative or relevant. And with reference to the specific sections that Ms. Whaley just cited, the second portion of the transcript that she would like to use is a section where language is used referring to Brett Hankison as angry and yelling, and basically the attorney doing the questioning testifying. There was no opportunity for Brett Hankison to cross-examine on that issue, for that matter, and for that reason, I think if you take it out of context or just cherry pick it out of the deposition, it's very prejudicial to Mr. Hankison. But if it's read in conjunction with the entire deposition, it's a little less stinging. So that's why I feel like it's an all or nothing proposition there.
Who was there representing Mr. Hankison at Mr. Cosgrove's deposition?
Kyle Vaughn and Ibrahim Farik.
Okay. All right. Is there a way that you all can get me that deposition today?
Yes, Your Honor. We actually, I could email the transcript, and the video I believe, was delivered to the court Friday. Our investigator was going to come and pick it up, and it's probably still there. The video, it's a flash drive with the video, but we can email the transcript.
Okay.
And it is 200 pages of testimony. I just looked at it. 200 of the 228 is actual testimony.
All right. So what I would ask you both to do then is to take another look at that transcript, and each of you give me the pages that you believe are relevant to our trial. And then I can make a ruling based on that.
Can I ask, Barbara, do you have any idea how long the video is?
I do not. I haven't seen it. Mr. Farroff might know since he was present for it. I don't know.
Mr. Beck, were you present?
No, Your Honor, I was not. Mr. Cosgrove was represented by Bill Bramall and Scott Miller, who represented him with regard to his employment situation with LMPD, but I was not present.
Does Mr. Cosgrove have just a guess as to about how long this video deposition lasted?
Judge, this is Miles Cosgrove. If I had to guess, it would be 2 hours to 2.5 hours.
Okay, thank you. All right. Well, based on Ms. Whaley's statements, Mr. Matthews' statements, taking in conjunction what Mr. Beck has told us that he has learned from the Department of Justice, I will find that Mr. Cosgrove does have a legitimate Fifth Amendment privilege that then makes him an unavailable witness for the purposes of our trial, and then we will sort through the civil deposition as to which parts of, if any, are to be admissible before the jury in this trial. All right. Anything else on that issue, Ms. Whaley?
No, Your Honor.
Or Mr. Matthews?
No, Your Honor.
Or anything, Mr. Beck, that you wanted to add?
No, thank you, Your Honor.
All right. So I'll excuse Mr. Beck and Mr. Cosgrove. Thank you all for calling in. Ms. Whaley and Mr. Matthews, if you'll remain on the line just for another few moments so we can maybe preliminarily talk about jury instructions.
Thank you, Your Honor.
Thank you. All right, Ms. Whaley, I think I had mentioned on Friday that I was hopeful that we could just at least preliminarily talk about the instructions. Obviously, it's 3 counts of wanton endangerment in the first degree. Anything else that you were going to propose, Ms. Whaley?
No, Judge, that's what we have drafted some proposed instructions.
Okay. And Mr. Matthews?
Yes.
Judge, I am working on the assumption that you have some standard boilerplate instructions that you give in a criminal case.
Yes.
In addition, I have prepared 6 proposed instructions that I will finalize this afternoon, but they all relate to justification and the United States Supreme Court decision of Graham versus Connor.
Can you give me that site?
Yes, if you give me just a second here.
Sure.
Graham versus Connor is 490 U.S. 386. It's a 1989 case. I can give you the Supreme Court or lawyers or LED at sites too, if you would like.
Oh no, that's fine. That's fine.
Okay.
Thank you for that. All right. So if I could ask,
Your Honor,
go ahead.
We have a case as well. I can actually email that along with our draft instructions, which is Commonwealth versus Caudle. And that site is 540 Southwest 3rd, 364, which is the Kentucky Supreme Court, 2018.
Okay. All right. Thank you. And then if both of you would email your proposed instructions to my staff attorney, and it's Bob McClure, MCCLURE at kycourts.net.
So there's no dot, it's just Bob McClure.
No.
Yes, we will do that.
I will do that also.
Okay, thank you. And so I'll be looking for that, the transcript. I'll take a look at these cases that you've cited, and then when you can get the instructions emailed as well, I'll take a look at those. All right. Anything else?
Thank you, Judge.
Anything else we should talk about today?
I don't think so.
Okay. Anything, Ms. Whaley?
Judge, there is one other issue in regard to the witness, John Mattingly. We would ask for a missing witness instruction, which has been approved by both the U.S. Supreme Court and the Kentucky Supreme Court regarding a witness who has claimed the Fifth Amendment. And obviously a jury cannot be told that, but under these cases, which I can also email, Clayton versus Commonwealth, which is a 1990 Kentucky Supreme Court, 786 Southwest 2nd, 866. And then Bowles versus United States, that's BOWLES. And that's, let's see, the U.S. Site, I don't have the Bowles site.
If you could just email it to me when you get the chance.
Yes. And under those cases, the jury can be advised simply that in the case of John Mattingly, potential witness, let's see. The court, I'm just going to quote from the Bowles versus United States. The court can instruct the jury that they should draw no inference from, and this witness was Smith's absence, because he was not available to either side. And that's it. That the jury should draw no inference from his absence because he was not available to either side. So we would ask that instruction be given regarding Mattingly. If for some reason we end up not using Cosgrove's deposition, then we would ask it also be given in regard to him.
Do you think if I gave such an instruction as to Mr. Mattingly that the jury may conclude that as a result of his injuries he was not available? I don't know that there's been any testimony. You know, the testimony that I've heard so far in the trial was that he was shot, that it was serious, that he was taken to the hospital. Certain people saw him at the hospital, that he was expected to live, and I think that's where it's been left. I don't think, there's been much testimony about his recovery since that time.
Well, we could put a witness on to establish that he recovered and has retired.
Okay. What?
I guess, can I interject here for a minute?
I didn't know if you'd had a chance to give this any thought at all, if this is new information to you regarding this missing witness instruction.
Well, I mean, my feeling is that he has never formally been called as a witness and failed to appear, so why would we call attention to it?
Well, because we can't call him when he's going to assert the fifth. He can't be called in front of the jury.
Right.
Well,
but if you want
I guess I would have to think about it more, but
sure.
I'm not sure it makes much difference.
All right. If you want to, spend some time this afternoon looking at that as well, and anything that you might want to respond, if you'll just email that to me or to my staff attorney also.
I will do that.
Okay. All right. Then I will look forward to seeing you all tomorrow morning at 9:30.
Thank you, Judge.
Thanks. See you then. Bye-bye.
Bye-bye.
See ya. Bye.
Sufficiency of the affidavits, the amended affidavits.
His supplement, I think, addressed the issues that we raised in our response.
All right, go ahead.
And Judge, I'm not sure that the affidavits really have much meaning in a petition for change of venue, especially in this kind of case here. So, but whatever, I think we've overcome that issue. The balance of this case involves the defendant Brett Hankison's constitutionally guaranteed right to a fair trial with an impartial jury, and the venue of or location of the trial plays a major role in whether he can get a fair trial, which is why we think that the court ought to seriously consider granting the motion. There's been an extensive amount of adverse publicity since this incident occurred on March the 13th of 2020. And all of it has been directed at basically the LMPD and more specifically at the officers who were involved in the attempted execution of the search warrant on Springfield Drive, and more specifically at Brett Hankison, since he's the only one that was charged with anything criminal out of this whole incident. I don't mean to suggest that all of the potential jury persons in Jefferson County cannot be fair and impartial. Far from that, but I think there are a large percentage of people who could not be fair and impartial. And I think every resident of Jefferson County is aware or will be aware of what has occurred since March 13th of 2020. And I think that there's subliminal pressure, if not direct pressure, on all of those people and fear of what could happen should they sit on this jury and should they render a verdict that is not the verdict that a large segment of the population wants. They saw what happened last summer here in Louisville, and I think that has to weigh, just by the very nature of human nature, it has to weigh on the minds and hearts of the people that were asked to sit on this jury. They have to return to their homes, their places of employment, their places of worship, where they shop, where they play. And when people know they're on that jury, I think they have a natural inclination that they will be afraid of what people are going to say or do with them. The publicity that has occurred has been extensive, and I think the court can take judicial notice of the publicity that has occurred with reference to the incident itself, but also there has been an extensive amount of publicity in the media about Brett Hankison himself related to unsubstantiated allegations of sexual assaults and unsubstantiated allegations of planting drugs on people. I even saw one article that was critical of him because of the amount of overtime he works. So I think that the air has been poisoned so much around Jefferson County, and not just Jefferson County, not just the city of Louisville or Jefferson County, but across the Commonwealth, across the country, and around the world. But it is not as pervasive in those other locations as it is right here in Jefferson County. And I think that all that negative publicity creates a presumption of prejudice against him. But I think also there's plenty of evidence of actual prejudice against Brett Hankison, and that takes the form of many of the exhibits I attached to the motion. When I came in here today, there are still banners of Breonna Taylor hanging right outside of the courthouse here. But more than that, Judge, there have been wanted posters posted around town. There are 26 billboards. I don't know if they're still out there, but 26 billboards that were paid for by Oprah Winfrey, all referring to Brett Hankison and John Mattingly and Miles Cosgrove as murderers. There have been stickers stuck on telephone poles around town. There have been postcards that have been mailed to people here in Jefferson County, all of which refer to Brett Hankison as a murderer. Social media has been going nonstop since his name came out. I just think we've had comments by the mayor, by politicians, by the former police chief, by athletes, by so-called celebrities, all directed at the LMPD, at the officers involved in the search at 3003 Springfield Drive, and more specifically directed at Brett Hankison, referring to him as a murderer. And that constant barrage of publicity and all those other things I just mentioned have got to create a prejudice amongst the potential jury pool. And for that reason, Judge, I think that
10:30, officer down. 10:30, officer shot on Springfield.
What's the location?
Officer shot on Springfield, 10:30. Isaac EMS. EMS is around the radio. We need EMS backing up here now.
I'm getting started.
Already down the street. Tell him to get up here.
Chris, okay, you're supposed to Springfield Drive. We have EMS in the way.
1 David on Springfield. Where y'all at?
3007 Springfield Drive.
Do not block EMS. Ram that gate. Ram that gate, patrol car. Ram that gate. Patrol, ram that fucking gate now. Ram it with your car. Ram it.
Pages, I believe.
Of the affidavits, the amended affidavits.
His supplement, I think, addressed the issues that we raised in our response.
All right, go ahead.
And Judge, I'm not sure that the affidavits really have much meaning in a petition for change of venue, especially in this kind of case here. So, but whatever, I think we've overcome that issue. The balance of this case involves the defendant Brett Hankison's constitutionally guaranteed right to a fair trial with an impartial jury, and the venue of or location of the trial plays a major role in whether he can get a fair trial, which is why we think that the court ought to seriously consider granting the motion. There's been an extensive amount of adverse publicity since this incident occurred on March the 13th of 2020, and all of it has been directed at basically the LMPD and more specifically at the officers who were involved in the attempted execution of the search warrant on Springfield Drive, and more specifically at Brett Hankison, since he's the only one that was charged with anything criminal out of this whole incident. I don't mean to suggest that all of the potential jury persons in Jefferson County cannot be fair and impartial. Far from that, but I think there are a large percentage of people who could not be fair and impartial, and I think every resident of Jefferson County is aware or will be aware of what has occurred since March 13th of 2020, and I think that there's subliminal pressure, if not direct pressure, on all of those people, and fear of what could happen should they sit on this jury and should they render a verdict that is not the verdict that a large segment of the population wants. They saw what happened last summer here in Louisville, and I think that has to weigh, just by the very nature of human nature, it has to weigh on the minds and hearts of the people that were asked to sit on this jury. They have to return to their homes, their places of employment, their places of worship, where they shop, where they play. And when people know they're on that jury, I think they have a natural inclination that they will be afraid of what people are going to say or do with them. The publicity that has occurred has been extensive, and I think the court can take judicial notice of the publicity that has occurred with reference to the incident itself, but also there has been an extensive amount of publicity in the media about Brett Hankison himself related to unsubstantiated allegations of sexual assaults and unsubstantiated allegations of planting drugs on people. I even saw one article that was critical of him because of the amount of overtime he works. So I think that the air has been poisoned so much around Jefferson County, and not just Jefferson County, not just the city of Louisville or Jefferson County, but across the Commonwealth, across the country, and around the world. But it is not as pervasive in those other locations as it is right here in Jefferson County. And I think that all that negative publicity creates a presumption of prejudice against him. But I think also there's plenty of evidence of actual prejudice against Brett Hankison, and that takes the form of many of the exhibits I attached to the motion. When I came in here today, there are still banners of Breonna Taylor hanging right outside of the courthouse here. But more than that, Judge, there have been wanted posters posted around town. There are 26 billboards. I don't know if they're still out there, but 26 billboards that were paid for by Oprah Winfrey, all referring to Brett Hankison and John Mattingly and Miles Cosgrove as murderers. There have been stickers stuck on telephone poles around town. There have been postcards that have been mailed to people here in Jefferson County, all of which refer to Brett Hankison as a murderer. Social media has been going nonstop since his name came out. I just think there's, we've had comments by the mayor, by politicians, by the former police chief, by athletes, by so-called celebrities, all directed at the LMPD, at the officers involved in the search at 3003 Springfield Drive, and more specifically directed at Brett Hankison, referring to him as a murderer. And that constant barrage of publicity and all those other things I just mentioned have got to create a prejudice amongst the potential jury pool. And for that reason, Judge, I think that the change of venue is warranted. In the cases I've researched, most of them are homicide cases. This case is not a homicide case. It's not related in any way. The charge is not related to Breonna Taylor in any way, and yet the media has treated it, as is evidenced by the media here today and as evidenced by the media out in the hallway, as basically as a referendum on the homicide of Breonna Taylor. It's not a simple wanton endangerment case. We need to, and I don't think there's any way we can divorce that, and divorce, more importantly, the jurors' minds from the fact that this case relates to Breonna Taylor. So it concerns me that the case law that I have reviewed, for the most part, deals with homicide cases and cases that with brutal facts and so on, but this isn't that much different. And in those cases, just about every one of them that deals with a change of venue petition is appealed because that petition was denied. And just about every case, except for one that I found, upholds the ruling of the trial court that the venue change was properly denied. I think this case here is a totally different animal. I think times have changed since most of those cases were decided, in the sense that there's a whole lot more publicity and publicity news outlets out there now. I don't know of any of those cases that involved the posting of billboards and stickers and wanted posters and so on. But the bottom line is, Judge, that if ever there was a case where a change of venue was warranted, I think this is it. And I recognize those cases there are no firm guidelines. There's no statutory guidance in whether a motion should be granted. It's all discretionary. It's with you using your discretion and common sense. And all I would argue to you is that if there was ever a case that merited a change of venue in order to protect the rights to a fair trial of this defendant, this is the case. One of the Attorney General's arguments is that there is cost and inconvenience associated with changing the venue. None of that trumps Brett Hankison's right to a fair trial by an impartial jury. And for that reason, I would ask you to grant the motion that we filed. Thank you.
All right, thank you. Mr. Lasowski?
Judge, like Mr. Matthews pointed out, we filed a brief that I think sets out our position in the relevant case law, but I'd like to make a couple of points that I think are important and disagree with Mr. Matthews respectfully on a couple other points. Venue is important. It's built in the county in which these crimes occurred. That's in our Constitution and the statutes authorized and put in play by our legislature. They do that because it's important in the communities where these crimes occur to have a fair and impartial jury from that county decide the facts and render their decision on guilt or innocence. And it's equally important here, unless there's compelling reasons to change the venue. There has been pretrial publicity. There's no question about it. But the pretrial publicity has been difficult and pointed at a number of individuals and entities other than Brett Hankison. It's been pointed at Attorney General Cameron, It's been pointed at the mayor, at the police department in general. There's not been pervasive and focused adverse publicity pointed at Mr. Hankison. The pretrial publicity alone does not is not dispositive of a question of whether change of venue is necessary. Pretrial publicity is just the beginning point. What has to be determined is that pretrial publicity such that a reasonable conclusion could be drawn that no fair jury can be selected for Mr. Hankison's case? We believe it can. The only case that has been overturned, that's the Jacobs case in Knox County, is far different from this one. That had a population of 15,000 in Knox County. We have 765,000 or more people in Jefferson County. It's a diverse population made up of many different races, religions, work, and many other different statuses of people in this particular community. And why is that important? Because that provides us a resource that can be used through rigorous individual voir dire, as the court has already said that it would do if we stay here, as occurred in the Huber's case, through rigorous and effective individual voir dire from persons who are brought from these diverse parts of our county. I believe that we can effectively identify the number of jurors necessary who are unbiased and willing to consider a decision based only on the evidence they're going to hear. That's what our courts here in Kentucky favor, as noted in our brief. The courts here, as Mr. Matthews points out, gives great discretion to you, Judge, to decide what's appropriate. And they also favor, as they did in Huber's and Whitler, the use of individual voir dire, and if the court deems it appropriate, questionnaires to ferret out individuals who may be biased one way or the other. And also, more importantly, to identify people who are not biased. They may have heard about Breonna Taylor. Probably few people have not heard about her death. But there are many people, I believe, in this community, and the community of Jefferson County where these alleged offenses occurred, who haven't formed an opinion and who would be willing to hear the evidence and decide fairly whether we have proven our case beyond a reasonable doubt without being interfered by Oprah Winfrey's bulletin boards or any other miscellaneous and unimportant data. I believe we have that kind of community here. It may take more than the usual couple hours that occurs in most voir dires that we've had in your courtroom in the years you've been a judge here. It may take several days. In Minnesota, it took 2 weeks. In a case far more graphically prejudicial on its face to the population in Minnesota, but they found a way to find 14 jurors who weren't biased through good and effective examination of those people individually. They may have also used, I believe, questionnaires. Our courts favor that, and I believe they favor, particularly in a county as large as ours, that's the appropriate way to decide it. If we come to a point where the court and the parties, it's obvious that and reasonable inference can be drawn that we're just not going to be able to get the requisite number of unbiased jurors, then that's the time, I believe. At that point, we've done what we can to give this community an opportunity to have unbiased jurors selected. Then we can look to alternative counties as set out in the relevant statutes 452. But I think the first and foremost, we need to give the opportunity for people in this community to hear this evidence and to make an unbiased decision about whether we've met our burden on these 3 counts. And as I pointed out, clearly there's been a lot of publicity, and undoubtedly virtually anybody we bring them will hear it, but that publicity has not pointed at former Detective Brett Hankison. It's pointed, as I point, to a number of individuals, including my boss, General Cameron. So, and I believe, and I strongly urge the court to allow us the opportunity with proper planning, with identification of potential juror pools, that we take the opportunity to individually voir dire these people and talk with them. The court will be able to ask questions. Mr. Matthews will be able to ask questions. Myself or my colleagues with the Special Prosecution Team will be able to ask questions. From those, I'm convinced we can determine who is biased, and that bias will prevent them, whatever side they're on, from being a juror. But I firmly believe that with that process, that we can select the 34 jurors we usually put into the panel, and then with the preemptive, with the strikes that were allowed, I think we could come to the 14, 15 jurors to hear this case, and 12 unbiased jurors to decide it. So, and I believe that's consistent with Whitler and other cases in Kentucky that favor that approach. A good example, the court's got our cases, but a good example was a 2020 case, Commonwealth versus Huber. It's unpublished, it's before you, but that was a case in which the defendant had been convicted in Campbell County, a county of 115,000, if my memory is correct, 1/6 the size of Jefferson County, but they noted the size of the county was important because it was diverse and represented a population from which the trial judge felt confident they could find the jurors necessary and unbiased to hear that case. Importantly, that the defendant in that case had been convicted, and that conviction was overturned on appeal. The reasons I don't recall, and it's not important for our discussion this afternoon. But many of the jurors knew that defendant had been previously convicted, which, as the court knows, having been an attorney for many, many years, and there's a retrial for whatever reason, the first rule is nobody mentions the previous trial because of the potential prejudice. That came up. Nonetheless, the court found that they were able to work with those jurors even with that knowledge and have upheld that conviction, finding that the court did properly do the voir dire, and through questionnaire and voir dire found the requisite number of jurors that were unbiased and willing to hear the case and make a fair decision based on the evidence. I think we can do the same. I think we can follow Huber's and apply those same principles that the trial judge did there and find the requisite number of unbiased jurors, do it here in Jefferson County where this alleged crime occurred in this community. And we can find people who can give this man the fair trial he's entitled to. And I'm convinced we can do that. And I believe the appropriate way to do it is to let us go forward with proper planning and whatever the court feels and the parties agree to, or on questionnaires, our selection, and how many jurors we need to get. I realize there's some complications there, but I believe those complications far outweigh the importance of having this trial consistent with the constitutional and statutory provisions in the county in which these allegations occurred. Thank you, Judge. And I stand by the briefs that we filed in response. Thank you.
Anything in response, Mr. Matthews?
Judge, just briefly, with reference to the pervasive publicity that has not been directed directly at Brett Hankison, I would disagree with that in the sense that the most pervasive negative and prejudicial publicity has been directed at the LMPD, and more specifically at the 7 officers who were involved in the attempted execution of this search warrant. And as a result of that, only 1 officer is in this courtroom facing criminal charges, and there's a large segment of the population that wants revenge for the death of Breonna Taylor. And unfortunately, Brett Hankison is the only person at this point that can be the target of that revenge. And for that reason, I think that alone suggests that the pervasive publicity has been extremely harmful to him and damaging to his right to get a fair trial. The comparison to the Minneapolis case, again, I think you're trying to compare apples to oranges in that case. This case is entirely different. I saw some of the beginning of that jury selection process, just a shot of the outside of the courthouse, and it's like an armed fortress up there. And again, coming in here today, there are still Breonna Taylor things. That kind of stuff can't help but affect the jurors the people we're going to ask to sit as jurors in this case. They know that there's a lot of pressure. And for that reason, again, this is an entirely unique case, but I think if there's ever been a case that merits a change of venue, this is it. And I'd ask the court to grant the motion. Thank you.
Okay, thank you. Obviously, there has been an overwhelming amount of publicity in this case, and it's not just been limited to publicity here in Jefferson County. The publicity has been very far-reaching. It's been on the national news. The stories have been on the national news, many, many times. There's probably been more publicity in Jefferson County because the events occurred in Jefferson County. But that's not to say that our surrounding counties have not also experienced that very same publicity. And I was really hoping today to hear something about how far-reaching the local media is to the surrounding counties, and whether going to an adjacent county would even help with the issue. I think I may have mentioned to you all in a previous hearing.
Just let me know when I can bring yours.
Okay. I didn't hear what you said. His testimony will be presented by video deposition from another proceeding. Anything else? Is that fine? I don't know that we have the date.
May 26, 2021 is the date of the deposition.
Okay.
Can we call it a civil proceeding as opposed to a criminal proceeding?
Do you want to do that? I don't know. I have no idea what they think about any of this.
Let's throw money.
Oh, it's working. If you think it should be.
I don't know if any of them would really know the difference anyways.
I'd say just another proceeding. They know he's not available. You are here.
Okay, and you're fine with this, the way it's written? Okay.
Well, I didn't see.
Yeah, go ahead, take a look. Okay, good. All right, ladies and gentlemen, anything to report from the break?
May I approach?
You may. Anyone else have anything to report? All right, very good. All right, ladies and gentlemen, at this time I want to read an instruction to you, so if you'll just pay close attention. You shall draw no inference from the fact that John Mattingly did not testify. He was unavailable to either party. You shall draw no inference from the fact that Miles Cosgrove did not testify in person. He was not available to either party. His testimony will be presented by video deposition from another proceeding, which was conducted on May 26 of 2021. He was under oath at that time. All right.
Your Honor, they're broken up into the clips that you permitted, so I will play one, play another, and play another. They are not all the way through.
Okay. And you understand that what I sent you was to be excluded, so.
Yes, ma'am.
All right.
Yes, ma'am. Morning. Good morning. Mr. Cosgrove, my name's Steve Romines. Mr. Moore and I represent Kenny Walker in this case. You ever done a deposition? No. Okay. Sworn testimony, like you've testified in court before, correct? Yes. Only difference is that we don't have a judge here and court reporter's taking it down rather than video. Okay. Now, by it not being on video, head nods, uh-uhs are harder for the court reporter to understand, so answer the questions verbally with yes, no, explain however you want to do it, okay? I understand. If anything, I'd ask you that you don't understand, just ask me to rephrase it, okay? Yes. We ever had a case together? I think so. Yeah, it was a long time ago. Yes. All right, could you please state your name for the record and spell it for the court reporter?
It is Miles Cosgrove, Miles with a Y, M-Y-L-E-S, Cosgrove, C-O-S-G-R-O-V-E.
And let's go off the record. All right, what's your current employment, Mr. Cosgrove?
I'm not employed right now.
Okay. How long were you with LMPD?
Approximately 15 years.
Okay. In various different roles?
Correct.
Okay. What are the SOPs? Just what
are they
generally speaking,
They
what's
are
SOPs?
rules and regulations, operating procedures.
That you're supposed to follow?
Correct.
Are you required to be familiar with them?
Yes.
And are you ever tested or certified on them?
You're not tested on them, no. You are you sign off on them as they're updated throughout the year.
When going into March 12th of 2020, when would have been the last time you personally reviewed the SOPs?
I don't know. SOPs are you are given your SOPs in the academy as all of them, and then throughout your career you are given SOP updates and familiarization throughout your career. So there is no review time per se.
When would be the last time that you would have reviewed an SOP about search warrant, execution of search warrants?
I don't know that answer.
Same with body cams. When the last time you would have reviewed one of those?
Correct. I wouldn't know that.
Okay. Now, when is it your understanding that it's permissible to deviate from the SOPs?
Well, SOPs are most of them are a generalization of what you should and shouldn't do. I can't really give you an exact example, but there are times when you need to deviate from set rules and regulations. It could be for exigent circumstances. It could be for something that you or the department isn't familiar with, something that has never happened before. It would have to be something that hadn't been thought of before, okay, for the most part.
So, and exigent circumstances, and that could include public safety or officer safety.
Correct, yes.
All right. And then something that's not covered by them.
Correct.
Other than that, though, you're supposed to follow them.
Yes.
Right. Had you ever worked with PBI prior to March 12th of 2020?
No, sir.
So this was the first time had you worked with any of the officers in PBI?
Yes, PBI was a new unit, so yes, I had worked with them in other aspects prior to
it becoming PBI?
To PBI, correct.
Okay. Who had you worked with?
Sergeant Kyle Meany, Mike Campbell, and Josh James. That's it.
But once they became PBI, you had never worked with that specific unit.
Correct.
What was your unit at the time on March 12th of 2020?
I'd only been in that unit for a few months. What the heck was it? It was called
CID.
CID, Criminal Interdiction Unit. Yeah. Well, that's narcotics. That was the new name of narcotics.
Okay. The new name of narcotics was CID.
I believe so. Yes.
Okay. Or was it a division of narcotics as a whole?
Shoot, I don't remember.
Doesn't matter.
I mean, I'd only been in the new transition for a few months, so I wasn't concentrating on names.
Okay. What were you? What jobs were you primarily performing in March of 2020?
Mid-level drug dealers, complaints, mid to low-level complaints and drug dealers.
Okay. Not parcels or anything like that?
No.
Okay. Now, did you have any role in the investigation of Jamarcus Glover?
No, I didn't have any role.
Did you have any idea who Jamarcus Glover was?
No, I didn't.
Until you went to the briefing that night?
I wouldn't say I knew who he was at the briefing. I was just told of the name and whatnot. So to who he was, no. The name, yes.
So had no role in the investigation at all?
Correct, no role.
No role in the preparation of the search warrant?
Correct, no role.
No role in the threat matrix?
Correct, no role in that either.
You ever see it?
That threat matrix, no. I have seen the threat matrix. before, but not that evening's.
For Springfield.
Correct. I have not seen that one.
Okay, so didn't see it before the search warrant
Correct.
was executed, didn't see it at the briefing.
Correct.
Never saw it any time.
Correct.
Did you have any idea who Breonna Taylor was?
No.
Did you have any idea who Janiyah Palmer was?
No.
That she lived at that address that you guys were executing a search warrant on?
No.
What about who Kenny Walker was? Did you have any idea who he was?
No, I had no idea who any of those folks were.
Had any idea that Kenny Walker was at the residence that you guys were executing a search warrant on?
No.
Did you have any idea if Jamarcus Glover was actually there, going to be there or not?
No. No.
So it sounds like you didn't really know anything about what was going on at 303 Springfield when you guys went to execute this search warrant.
No, I knew what was happening, or I knew the plan, but I did not know the occupants or the targets that we were going after, if that makes sense.
Okay. What is a surveillance officer's job?
A surveillance officer's job is to report, obviously, what they surveil or what they see to parties that have an interest in what we're doing.
So-
They need to report who, what, when, where, to the folks that need the information in a timely manner.
So if you're executing a search warrant and you have a surveillance officer observing the location, one of the things one of their jobs is to convey the information timely to the people executing the search warrant.
Yes.
Of who's there.
Well, they may not know who is there, but bodies that are there, correct?
If not the actual persons, but if 5 people are there, they're supposed to convey that to you.
Correct.
If one person's there, they're supposed to convey that to you.
Yes.
If people leave, they're supposed to convey that to you.
Yes.
And people arrive, they're supposed to convey that.
Correct.
Okay. Was any of that information ever conveyed to you or the individuals executing the search warrant?
I was told that there was one individual at the apartment, which would have been the female, Breonna Taylor.
And as we learned,
it was described, I remember it as a heavy-set female as at the apartment.
okay, and that you learned that in the briefing?
Correct.
And as we now know, there was more than one person there.
Yes.
And had arrived that evening.
At some point, yes.
But that was never conveyed by the surveillance officer who was watching the location.
Correct. Not to me, but yes.
Well, and as one of the people executing this search warrant, if that information is conveyed to anyone on the team, it should be conveyed to everyone executing the search warrant.
Yes, it should. Immediately, yes.
Because executing a search warrant really is one of the most dangerous things that law enforcement can do.
It is inherently dangerous, yes.
It's inherently dangerous. And if you don't have proper intel, it's even more dangerous.
Yes, I would agree with that.
And if you don't know who's in the location, it's even more dangerous.
Yes.
If you don't have an accurate threat matrix, it's even more dangerous.
Yes.
If it's not planned properly, it's even more dangerous.
Yes.
And if you have a combination of multiple factors, such as we just mentioned, poor planning, poor threat matrix, poor intelligence, poor surveillance, that makes it even more dangerous.
I would say poor planning and all those things that you listed make it inherently dangerous. I'm not agreeing that evening those facts were poorly planned and whatnot. But yes.
We'll cover that.
But factors that are overlooked for any plan can make it more dangerous, yes.
So if certain, you don't have to concede at this point that these things happen. We'll just talk about them. If surveillance is improperly performed or poorly done, that makes it more dangerous.
Yes.
If intelligence is improperly performed and poorly done, that makes it more dangerous.
Yes, it does.
If the planning of the actual stack and raid is improperly or poorly done, that makes it more dangerous.
Yes.
If the threat matrix is inaccurate or improperly done, that makes it more dangerous. Yes. And you combine all of these various factors that make something that's inherently dangerous even more dangerous, it gets to be pretty foreseeable that something bad could happen, doesn't it? You can answer.
If you're overlooking dangerous factors that you're saying, yes, it would continue to exponentially make what you're doing more dangerous.
And there comes a point when if you continue to stack one thing after another, that it becomes likely that something bad's going to happen, or definitely foreseeable.
It would compound in the error, yes.
Now, you've indicated that you were told to assist in the execution of this search warrant.
Correct. I volunteered to assist in working that night. I was assigned a task.
Okay. Now, did you volunteer via email or sign up, or how did that work?
I don't remember exactly, but it would have been one of those ways.
Okay. Now, you previously indicated in your interview with PIU that all of CID was told to assist.
Well, I believe that's all on overtime. They can't make you work overtime, so that may have been a mischaracterization, but
You can start right there, just to see if that refreshes your recollection, or you can correct it, or how you want to do it. 1:30.
Okay, my fault. Well, this is saying that I was told to go to the roll call room, not that I was told to assist in the actual voluntary of the incident.
So you were not told to assist in the execution of the search warrant. You volunteered.
Correct. Yes, sir.
All right. Okay. Let's just cover exactly what you said in your interview. You started at approximately.
Sorry, what are we reading from?
Is an interview from PIU. Starting at line 132. So approximately.
So at approximately 10 o'clock, we were told to all of the narcotics or CID was told to meet in the roll call room to assist unintelligible unit with several. We were with unit with several warrants that they were briefing.
Okay. Now, is that what is in your interview?
Correct. I'm saying that I was told to go to the roll call room to participate in the brief.
Okay, so you weren't told to assist the unintelligible unit. Presumably that's PBI.
Can you say that again?
Yeah. You say, so at approximately 10 o'clock, we were told all of the narcotics or CID was told to meet in the roll call room to assist the unit with several warrants that they were briefing.
Correct. So I'm in an office space, and I'm being told to go to a briefing room. I'm being told to move from one location to another location to attend the brief.
So you weren't told to assist in the execution of these warrants. You were just told to go to the briefing room.
Correct.
All right. Now, how did you volunteer to assist in the execution of these warrants?
I don't remember exactly, but it's typically email or verbal, voluntary, or through phone call.
And who conducted the briefing?
I'm really bad with names. So the female officer, Kelly Hanna, and Wes Barton were the folks that I remember as having a speaking role in the briefing room.
So you don't recall Josh James conducting the briefing?
Correct, I don't.
Recall anybody else speaking at the briefing?
No.
What was covered at the briefing?
It's a big question. They're covering all the locations we're going to. They're covering the targets. They're covering individual unit responsibilities. They're covering timelines.
Cover who was in charge
of the entire brief. I don't remember that. I know they would, on your stack it is covered who is in charge, or on your particular assignment.
Okay, who was in charge of your particular assignment?
Lieutenant Sean Hoover.
Okay. Is that reflected in the briefing on the whiteboard?
I would think so, as the order of, I'd have to look at that photograph, I'm not sure.
Okay. I'll show you in just a minute. We'll go down here to the lead detective's obligations. What does that indicate?
2631 lead detective. Prior to serving the search warrant, the lead detective may request assistance from the tactical operations team with videotaping the location unless exigent circumstances exist. The lead detective is also responsible for the following.
Keep going.
For the following: number 1, notification of a supervisor; 2, completion of the search warrant matrix or risk assessment matrix; number 3, completion of the search warrant checklist; number 4, completion of an overall completion of an operation plan; 5, securing the approval of the operation plan; 6, entering pertinent information about the search warrant location in the HIDTA, HIDTA, which is HIDTA deconfliction software; and 7, being present at the pre-service briefing.
Okay. Now, to your understanding, who is the lead detective in this case?
PBI Josh James.
Okay. And he was not present at the pre-service briefing, correct?
Not. I don't remember him being there. Correct.
Okay. Are you aware if the information was entered into the regarding the search warrant location entered into the HIDTA deconfliction software?
No, I'm not.
Okay. Are you aware of the operation plan being approved by a supervisor?
The operations plan could be construed as the whiteboard. The operations plan, even for me, would have been the whiteboard, and there are commanders there. So I would say yes, that is, from how I'm looking at it, yes, that has been approved.
Are you aware of a requirement of a written operations plan?
Yes, there is a requirement for a written document.
And that wasn't done, was it?
Not that I know of.
Okay. So the requirement for the SOPs requires a written operations plan to be done before a search warrant is executed, correct?
Correct. But folks in the briefing are not, it's not pertinent information that you're given.
Okay. My question was, the standard operating procedures for the execution of a search warrant, which we've established is inherently dangerous, requires a written operations plan.
Yes, it does.
And that was not performed, was it?
I don't know.
You never saw it?
All I know is, correct, all I saw was the whiteboard information.
Okay. And according to both narcotics as well as the general LMPD's SOP, writing it on a whiteboard is not permitted as a substitute for a written operations plan, is it?
That's a yes and no question for me, because you may have a warrant that needs to be done quickly. So your operations plan may be written on the windshield of a car with a marker. And then later on you go back and you type up your your document per se. But I don't know if that was done that evening.
Okay, well, do you have any reason to believe that a search warrant that contained information from January 16th, 2020, and was executed on March 13th of 2020 had to be done immediately?
No, yes, that should have been done within that time frame.
It should have been done. It's required to be done. To your knowledge, it wasn't done.
Correct. I don't know if it was done. Yes.
Okay. And while we're talking about it, we'll look at the general LMPD's preparation for search warrant. Now, I've highlighted for you there. Yeah. They will be. This will be Exhibit 2. I know. Narcotics is one. 2 copies of that. Yep. What does that indicate?
8.1.
He is looking at Standard Operating Procedure, SOP 8.1, search warrants. And he's looking specifically at 8.1.17, preparation for search warrant execution. Go ahead, you read it.
8.1.17, preparation for search warrant execution. The highlighted area, the lead officer will complete a search warrant operation plan form LMPD 050025. Prior to the warrant service, the on-scene commander will act as the incident commander for service of the search warrant, and the incident command system will be implemented and followed. The IC incident commander will conduct a briefing with all search team personnel. This briefing will include 1, a review of the operations and procedures that the search personnel will follow. 2, an analysis of conditions at the premises utilizing maps, charts, diagrams, appropriate tactics and equipment that are being used in the event of forced entry, a pre-planned hospital route.
Okay. Now, this is, again, these can be disregarded under exigent circumstances or public safety.
Yes.
Right? And
well, no. Those all need to be done in some form. If you don't do those things, then in some form they have to be done prior to doing anything, exigent circumstances or not.
Okay. And the search warrant operations plan that is required by policy has an actual specific form, doesn't it?
Yes, the operations plan, yes, has a tracking or a form number, yes.
Yeah. Because, again, we're talking about something that is inherently dangerous.
Correct.
And there are several policies and procedures put in place to try to make it less dangerous.
Yes.
And one of those is the search warrant operations plan.
Yes.
And a specific form that has to be filled out before a search warrant is executed.
Typically, yes, that form would be filled out unless there were mitigating circumstances that wouldn't allow it for the time.
Yeah, exigent circumstances or public safety.
Correct.
And again, none of those exist in this search warrant, do they?
I don't have knowledge of that.
So we know that wasn't performed, the search warrant operations plan. The on-scene commander will act as incident commander. Who's that?
The on-scene commander typically is the first person on scene. For a warrant, for a search warrant, it would be the person with the most, it would be the person who's warranted is, because they have the most information.
Okay, and that would be Josh Jennings.
Not necessarily. Someone who is giving the briefing may have as much information that John had, that James has.
Okay,
correct.
now we just covered in the narcotics SOPs, the lead detective, who is James,
Correct.
is required to be at the briefing.
That's what that says, yes. There are mitigating circumstances. His supervisor could have approved it, but typically a lead detective, someone who has intimate knowledge with what you're about to do, typically gives a brief.
Well,
And I, again, may be incorrect that he was in there or not.
so you think he might have been there?
There was a lot of people in there.
You just don't recall seeing
I
him?
don't recall him being in there, correct?
And you don't recall him doing the brief?
Correct.
However, again, under the Narcotics Division's own internal policies, the lead detective is required to be present at the brief.
According to that, yes.
Okay. Well, this is the Narcotics Division's own policies, isn't it?
Yes, but we agreed earlier that policies can be changed for certain reasons. And again, if Josh had something that had to be done, and other individuals have that same intimate knowledge of what's happening, it would be appropriate for them to give information to the folks in the briefing room.
So if there's a public safety issue that Josh is dealing with, or there's exigent circumstances that require him to not be present, then obviously the SOP can be ignored.
I would object to this entire line of questioning. SOPs and the narcotics document speak for themselves. This witness has already testified that he had no role in planning, preparing this warrant. Calls for speculation. Other witnesses with knowledge, this witness doesn't have it.
Objection noted. All right, you will. Is it your testimony that even without exigent circumstances or public safety issues, that this requirement that the lead detective be present at the briefing can be ignored?
Yes, it can be. There are other reasons that would have to be between that unit and those supervisors on why individuals aren't there.
What are those other reasons?
Same objection. I still notice knowledge.
No, I mean, if you...
What are other reasons?
Yeah, you think there's other reasons? What are they?
There could be vital intelligence that he needs to convey to other people. There could be other intelligence that he needs to report to other, like SWAT, for instance.
Mm-hmm.
Maybe he has to tell other units very vital, important information. I can come up with scenarios, but I don't really know the answer to that question.
Well, there are none listed in any of the SOPs other than exigent circumstances and public safety. You can't just ignore them because you want to, can you?
No, correct.
And and again, as we established earlier, they are put in place for specific reasons.
Yes.
And they are best practices.
Yes.
And one of the reasons there are so many SOPs concerning the execution of search warrants is because it's inherently dangerous.
Yes, it is.
And the SOPs are designed to make it as safe as possible.
Correct.
And when they are ignored or disregarded, it becomes less safe.
Yes.
Now, as we just covered with this document here, okay, which is the LMPD's SOPs, okay, at 8.117.
I don't have that. Okay, I got you.
Preparation for search warrant. 8.1.17.
Credibility.
0.17.
I got you.
There you go.
Field operations preparation.
Preparation for search warrant. In the first paragraph, what is the last sentence in the first paragraph?
The lead officer will complete a search warrant operations plan, form number 05002.
And as we just covered, Josh James was the lead officer, to your understanding.
Correct.
And there is a specific search warrant operations plan form that LMPD has prepared.
Yes.
And it's required, there's nothing in this SOP that says we'll complete a search warrant operations plan form if he so chooses, or at his discretion. It's required, isn't it?
Yes.
And to your knowledge, it was not done in this case.
I don't know if it was done or if it wasn't done or when it was done. Correct.
You never saw one.
Correct.
And then the next paragraph, prior to the warrant service, the on-scene commander will act as incident commander. And we just talked about, your understanding would be that would be Josh or that would be Hoover?
So prior to the search warrant, the on-scene commander will act as the incident commander for service of the search warrant, and the incident command center will be implemented. So prior to the search warrant, we are in the office. So the on-scene commander, the incident commander would be Josh J, or whoever is giving the briefing.
Okay.
Whoever I'm being told is in charge of these warrants.
Okay. The IC will conduct a briefing with search team personnel. The briefing will include a review of operations and procedures that the search personnel will follow.
Correct.
Did that occur?
Yes, there was a briefing, and there is a plan that is discussed in the briefing.
What was the plan discussed?
That's a really big question, because there's multiple locations. So
I'm talking about on your team.
Which part of the plan? Like the entire plan?
How you're going to make entry, if entry's required, who's carrying the ram, who's first, who's got the ballistic shield, all these things. What was covered?
Part of that was covered in the briefing room, and then part of that was covered in the parking lot prior to going to the location.
Okay. Which part was covered in the briefing room?
Who would be there, the who, what, when, where, and why. The particular jobs, like the VO job, the administrative jobs that we're going to do. Who is in charge?
And who was in charge? Who did they say was in charge?
Lieutenant Hoover is the highest ranking person there, so he would be in charge.
Okay. Now, was that changed during the course of the briefing?
Of who was in charge? No.
And you indicated what's covered as the who, what, when, where, and why.
Correct.
What was the what?
The what would be the location or what we're looking for.
Okay.
That's just a generality that I'm saying. You want as much information as you can before you leave that room.
And that would be who's there, who all's there.
Correct.
Layout of the place.
Yes, you'd want all intelligence that the briefing team has conveyed to you prior to you leaving that room.
And that would be valid, legitimate intelligence, not stuff that's incorrect.
Correct. Yes, you would not want incorrect information.
Because that makes it even more dangerous. Having no intelligence is not as bad as having incorrect intelligence.
Yes, I would agree with that.
And as we learn in this case, believing there's one female there, when that's the intelligence you're given, becomes even more dangerous when you subsequently find out that there's another male there.
Incorrect intelligence is dangerous. Multiple parties at a residence exponentially increase the danger.
And again, you guys did not understand or were not advised that there were multiple parties there, did you?
Correct.
And not having that information made this situation more dangerous.
Yes, it can.
It did in this case, didn't it?
Correct, yes.
Okay. I'm going to show you what's been marked as Exhibit 3, which is a picture of the whiteboard. Yeah. Okay. Now, do you you see Springfield on that?
Yes.
Okay. And you indicated, no, I'm not done yet. I'm gonna ask you some more questions about that. Okay. Who is listed under Springfield?
Sergeant Mattingly, Mike Campbell, Nobles. I'm not sure how to say this name, but Dorr, James King, Cosgrove, Hankinson, and Franklin, who is a dog. Okay. What is it?
Now, you indicated that you all were advised that Hoover was the incident commander.
Correct.
Sure. Sorry. Hoover was the incident commander. And also, I asked you, was the board changed over the course of the briefing? You indicated no, not to your knowledge. Hoover's not on Exhibit 3, is he?
Correct. I don't know when this was taken, though. But no, he is not on this picture, or in this picture.
And Josh Dorr, didn't go to the scene, did he?
Correct.
And Colin King didn't go to the scene, did he?
Correct.
So the search warrant operations plan, or whatever this is supposed to be on the board, isn't even accurate, is it? Objection to the question. It's not accurate, is it?
Correct. Those individuals did not go with us.
Okay. So, and even if this is the information contained in the briefing, what's on this board, again, we're operating on stuff that's not correct.
Well, search warrants and police work it's flexible. It's always changing. But these folks were not at the location. Okay. So it is.
It's not accurate.
It is not accurate.
Okay. And I'll show you what's been marked as Exhibit 4, which is a different picture of the same board. Now, what do you see that's different about it? Sure.
It is different in that Lieutenant Hoover has been added to the bottom. Okay. And that's it. Just Lieutenant Hoover's been added to the bottom.
Okay. Has Noble's name been changed?
There's no K in Nobles on this picture here, or on this picture here.
Yeah. Exhibit 3, Nobles was spelled with a K, and Exhibit 4, Nobles was spelled with an N.
Correct.
Okay. So at some point in time, somebody made changes to these whiteboard that we're using as a search warrant operations plan.
Again, police work is very flexible. I don't know if I've ever been to a briefing where they have not changed the whiteboard as they're giving the brief for whatever reason.
Is the search warrant operations plan form, LMPD 050025, allowed to be changed whenever?
I don't know.
And we don't know if it was in this case or not because we've never seen one, have we?
Correct.
And there's no exemption, as we covered already, for writing on the whiteboard being a replacement for the search warrant operations plan, is there?
The operations plan needs to be complete at some point.
And not completing it makes the situation more dangerous.
The operations plan, this is my operations plan. When I go to the briefing, this is my operations plan.
Okay. Does any of this, either one of these pictures, reflect who's on the ram?
No.
Does it reflect where the people are in the stack?
No, this is just a list that is put on the board, and the incident commander or someone in this group you guys will have your side brief, because you may not know the strengths and weaknesses of each team member until you have your parking lot meeting, or what I call a parking lot meeting.
Is that always done? Parking lot meeting?
To some extent, yes. Yes. You may want to walk through or rehearse or double check equipment. So yes, in some form.
Was there any walkthrough done in the parking lot in this case?
We had a meeting, for lack of a better word, in the church parking lot off of in the church
St.
parking lot,
Andrew's Church.
St. Andrew's Church area over there. So yes, we had a parking lot brief.
Was there a walkthrough done?
No, and when I mean walkthrough, I'm meaning, you're making sure you got if you have the RAM, well then you should have it in your hand. Like an equipment check, a familiarization. You make sure that everybody that's supposed to be on your team is with you in this parking lot. You're like kind of walking through what's happening and who's with you.
And do you discuss who's where in the stack as you're going in?
Yes, those assignments would be determined after this briefing with the folks you're working with.
Okay, is that where everybody's role in the entry of the search warrant covered in the briefing that was done in this case at CID or in your parking lot meeting?
It could be, but I remember it as our role was occurring in the parking lots.
Okay, so it was not covered in the briefing?
I don't believe it was, no.
Okay, so it was just going to be up to you guys when you had your second meeting to determine who does what, everyone's role?
Correct.
Okay. Now it's fine.
Off the record at 10:57. Back in the record at 11:04.
I think where we stopped, we were talking about the briefing at headquarters versus, and we'll use the phrase parking lot briefing, and what's covered in each of them. And I'll show you again, you've got in front of you the LMPD's SOPs. Go to 8.1.17. And we covered the lead officer will complete a search warrant operations plan, which wasn't done. The on-scene commander will act as the incident commander for the service of the search warrant. And the incident command system will be implemented and followed. What is that?
The incident command system is a command and control. So typically it's the first person on scene who is in charge, and then as more folks arrive, that command structure starts to fluctuate based on either experience or rank.
Okay, so is that not determined at the briefing, or who's in charge of a search warrant execution? Or is it just whoever the next highest ranking guy is?
Can you say that again?
Okay, what I'm trying to determine is, was the incident commander determined when you all left the briefing room, or did you all determine that in the parking lot?
No, that is predetermined based on Lieutenant Hoover's rank.
Okay, so he was the incident commander.
Yes.
All right. And it says, if you keep reading there on the second paragraph, the IC will conduct a briefing with search team personnel.
Correct.
Now that would be Lieutenant Hoover.
Yes.
Did he conduct the parking lot briefing?
Yes. A parking lot briefing is conducted by someone who has rank and experience. A parking lot briefing is where you get your assignments and then you talk it through.
Okay.
So yes, that was conducted.
And what assignment were you given? Were you given any assignment at the briefing at the station?
I was assigned to the locations.
But that's it?
Correct, yes.
Your role in the execution was never covered in that briefing?
At the station, correct.
Okay. Was anything else covered in the briefing at the station other than this is where you're going, this is who's going, and we're looking for dope or money or whatever?
lot of things explained. What are you referring to exactly?
What else was covered in the briefing at the station with the whiteboard?
It was covered that this would be a knock and announce warrant. It was covered that there would be a heavy-set female there. We were given the task of finding documents, not necessarily drugs. And I'm sure there are other things, but those are the ones that stand out.
Did you ever think to yourself, why are we going in at 12:30 at night looking for documents?
No, that is all. I'm being asked to assist. That planning is above me. That's predetermined.
That's not your role.
Correct.
Right? You're not allowed to question.
I'm allowed to question it. Yes, but that did not come up.
Have you, subsequent to this, wondered why were we going in at 12:30 at night looking for documents?
No, that's part of their planning logic, and I wasn't part of that and haven't been provided any documents as to why they decided to do that.
Do you have any reason why SWAT wasn't consulted?
SWAT was consulted. SWAT was consulted if SWAT was there at certain locations, but I was not part of that.
Do you believe SWAT was consulted on the Springfield warrant the night it was executed?
No, I didn't know if they had or hadn't.
Would that also be information that's not part of your job requirement in this case?
Correct.
Now, we keep going here of the incident commander will conduct a briefing with all search team personnel. The briefing will include a review of operation and procedures that the search personnel will follow. Okay. Now, I think you're saying that occurred in the parking lot. It did not occur at the briefing station.
That's how I remember it, yes.
Okay. What was covered?
Well, are you referring to Lieutenant Hoover, or is that what you're referring to?
Whoever the IC was that will conduct a briefing with all search team personnel.
Are you talking about in the office or in the parking lot?
Either one. Did they cover?
Yes, that was covered. Your task, yes.
Okay. The operation and procedure was covered at both the briefing, at the station, and in the parking lot, or just in the parking lot?
The operation, which is the whiteboard, is covered in the office, and then our operation is discussed in the parking lot.
The procedures you're going to use to make entry was discussed in the parking lot?
Correct, yes.
Okay, and that's who's where?
Yes.
Who has what equipment?
Correct.
Right? Whose job is to do everything?
Correct.
Now, again, you're planning this out before you execute what you said is an inherently dangerous situation.
Yes.
Can you just change your mind? Once you're assigned a role, can you just say, nah, I don't want to do that, I want to do something different when you get there?
You cannot deviate from the plan. You can talk to folks and tell them why you may want to look at a different angle, but no, if you're given a task, you need to do that task.
Everybody has a job.
Correct.
And if people don't do their job, again, it becomes more dangerous for everybody.
Yes, problems can occur if you don't do any type of job.
Okay. And you all in the parking lot were all assigned a specific job.
Yes.
And what was yours?
My job was what I call perimeter or perimeter security. So folks call it different things, but I'm one of the perimeter individuals.
And that you understood that was your job to do.
Correct.
You're not responsible for the RAM.
Correct.
You're not responsible for making first entry.
Correct.
You're not responsible for ballistic shield.
Correct.
You're not responsible for backup of the person with the RAM.
No, that is incorrect. Police work is fluid.
Okay.
And if you see things that need to be corrected, you have a duty to correct them or to, let other folks know that there is an something that needs to be corrected or dealt with.
We'll get that. That's what I'm asking is, there came a point in time when you realized that Nobles did not have backup.
Correct.
Right? And that was much more important than you guarding the perimeter.
Correct.
So you, at that point in time, realized my job was here, but I need to change jobs because somebody has to back him up.
Correct.
Now, presumably in the parking lot, somebody was assigned the job to back up Nobles.
Correct, presumably, yes.
Because, again, that's a very important part of this entire procedure.
Yes.
And whoever got that assignment wasn't doing it.
Apparently, yes.
And you had to change in the midst of it, change jobs, so to speak.
Mm-hmm.
And I think whenever you're having to make decisions on the fly on something that's done like this, it makes it more dangerous.
I would say it makes it complicated. Not necessarily dangerous, but it makes it a little bit more complicated.
Changing a plan in midstream is complicated in itself, isn't it?
Well, the plan wasn't changed. A job was changed.
Okay. And who wasn't doing their job? Who was assigned to back up for the Ram?
I don't know.
So you were at the briefing. One of the important jobs is back up for the guy actually making entry. And you don't have any idea who was supposed to back him up.
Correct.
This is pretty poor planning in and of itself of the actual entry, isn't it? You can ask.
Not that I don't remember. So it very well could have been planned, but I just don't remember whose job that was.
You don't recall anybody being assigned back up for the guy with the Ram.
Correct.
Now, that is actually one of the procedures that has to be covered in the briefing, isn't it?
I would think so.
Along with who's got the Ram, who goes in first, those type of things.
Yes.
Now, if you'll look at bullet point 2 of the briefing requirements.
An analysis of conditions at the premises utilizing maps and charts and diagrams when appropriate.
Yeah. Did you have any idea the layout of the apartment?
No.
Okay. That would be information that would be helpful, wouldn't it?
If it's available, yes.
And again, do you know if it's available simply by calling the apartment complex and asking for a diagram?
Again, that's not my job to do that, so I don't know the answer to that question. I don't know if an apartment person can provide us that information in that timely manner either.
Well, again, I'll show you Exhibit 5, which is.
Yeah, what are you asking?
The layout of the apartment.
No, not that. I mean, the earlier doc.
Yeah. SOP, LMPD's SOP preparation for search warrant, 8.1.17. Now, wasn't your job to obtain this, correct?
Correct.
Did you ever see one?
No.
Right? You are aware of anybody ever attempting to obtain one?
No.
And again, a scene diagram of where you're going is something that would be beneficial.
Yes, I would agree with that.
It would make again, this is part of the intelligence that you have, makes a dangerous situation less dangerous.
The more information that you have mitigates some dangers, yes.
And again, the requirements of the SOP says an analysis of the conditions at the premises utilizing maps, charts, and diagrams when appropriate. If it's available, it should be information that's provided to you, shouldn't it?
Objection. One more question.
All information should be given to to folks that are doing a search warrant if it's available, yes.
And again, if it's not available, then look for it. And if it can't be found, then it can't be found.
Objection, has to be considered, and also calls for testimony as witness already stated.
You can answer.
I forgot your question, I'm sorry.
Before you send 8 fellow law enforcement officers into an inherently dangerous situation, you should exhaust reasonable efforts to give them a scene diagram, shouldn't you?
Yes, you should provide as much information as you can to the folks that are working your job.
And failure to provide it puts them at risk.
Failure to provide information to folks working any kind of job is
dangerous.
It's dangerous.
And if it's an inherently dangerous job, such as executing a search warrant, it's even more important, isn't it?
Yes.
The next thing the bullet point covers, tactics and equipment that are to be used in the event of a forced entry. And this is supposed to be covered in the briefing. Was that covered?
Yes.
Okay. And again, I think we established you guys didn't do a walkthrough, but did you have any idea that amongst your team there was a ballistic shield?
No. Well, not in the parking lot, no.
Yeah. In the briefing that you guys have regarding tactics and equipment that are used in the event of a forced entry, one of the tactics and equipment is a ram.
Correct.
The other one would be a ballistic shield.
Correct.
Right? And how, to your understanding, how does a ballistic shield work?
So I'm not a trained person on a ballistic shield, so I can give you a layman's version of it, but it is a bulletproof shield. It is inherently complex to operate. You would think it is easy, but it has limited vision. It's heavy. You have to have someone controlling the person who has the shield, giving this person directions. I am not a shield person or what's the term I'm looking for, like a shield operator, so I don't know much more than that about a shield.
You've not been trained on it?
I am familiar with it, but not trained to. I would not be comfortable to use a shield.
Okay. Yeah, and that's what I'm asking. You've
Yes.
not been trained on using a shield. Have you ever done a search warrant when a shield was used?
Yes.
Have you ever done a search warrant where the shield was used?
Yes.
Okay. And is it designed for after entry is made, the shield goes in first?
No, the shield would go first. That would defeat the purpose of the shield if it's going after, typically.
Yeah, the way it's designed is ram breaks the door if that's required. Then the shield goes in regarding to protect anyone from shots.
Yes.
Right. So and
typically, yes, that would be yes.
It doesn't make sense for shield to be last.
Not typically, no.
And in fact, since you've talked about it in some of your interviews, you were upset to learn as you guys were getting ready to go in that you all had a shield available.
Correct. I think I used the word irritated that we had a shield.
So in the parking lot briefing or the briefing at the station, nobody conveyed to you or to presumably to anyone else, oh, you guys have somebody with a ballistic shield.
Correct.
And that information would be inherently valuable, wouldn't it?
Yes.
Because that person would go first.
Yes, it would change the plan.
Right? And then as you guys are walking in, and you've already done this plan in the parking lot and the briefing at the station, you look around and you see a guy with a ballistic shield.
Correct.
And it irritated you because we've not planned for that at all.
Correct.
And again, that is one of the things that is covered in the SOPs of the tactics and equipment are to be used in the event of a forced entry. Ballistic shield would be one of those things.
Correct.
And that was never covered.
Correct.
And again, as I keep talking about it, but that made a situation that's already dangerous even more dangerous.
All I knew was that I was not informed of the shield, and that's of utilizing the shield. So when I say I'm irritated, I'm saying that I was not informed of this detail or this part of the plan.
And again, that would be valuable information.
Yes, it would.
And just to be clear, you weren't aware of it because it wasn't covered in the briefing at the station.
Correct.
And it wasn't covered in the briefing in the parking lot.
To my knowledge, it was not.
I mean, you were there. Were you there the whole time in the parking lot?
We arrived at staggered times, but yes, yes, I was.
They didn't start the briefing and then you show up halfway through.
No.
Okay. And had it been covered, again, I assume these situations are, you're paying close attention in these briefings.
If you're an intelligent person, yes.
Yeah, you were paying close attention.
Yes.
Because you know it's risky.
Yes.
Know your job, know what you're supposed to do.
Correct.
And if it had been covered that, hey, we've got a ballistic shield, you would have noticed that.
Yes.
Okay. It was not covered, was
To
it?
the best of my knowledge, it was not.
And again, that could be information that was also obtained or would be contained in a search warrant operations plan.
Yes, it should be.
And one was never done, to your knowledge.
To my correct.
And based on what we've talked about to this point, none of these things that have occurred up till now, did you have any role in? Other than showing up at the briefing and going to do the job that was assigned to you?
Yes.
Okay. Like the search warrant, the intel being provided, the lack of a layout, the incident commander or the lead detective not being at the briefing, not knowing who's got a ballistic shield, not knowing exactly how we're going in or whose job. None of those were your responsibility, were they?
Correct. Correct. I did not provide. Correct. Yes.
And as entry is being, and we'll talk about the knocking and whatnot, but entry is being made forced entry is being made into the apartment.
Yes.
And you realize at that point in time, you're doing your job of covering the perimeter.
Mm-hmm.
And you realize that someone either was not paying attention in the briefing or didn't get the assignment to cover the guy with the ram.
I know that someone is not with the ram. That's all I know.
And I think we covered, that is not something that we would just forget to do. That job would be assigned.
Yes.
Okay. And as you're doing your job of covering the perimeter, you recognize nobody is covering that guy who is really in the most danger of anyone.
In my opinion, yes.
Right? So you take it on yourself to change jobs on the fly and go and cover him.
Correct.
Search warrant preparation.
Correct.
No role in the investigation of Jamarcus Glover. No role in planning the search warrant execution.
Correct.
No role in conducting any of these briefings.
Correct.
None of these things were your responsibility. You didn't know it at the time. You know it now, don't you?
I wouldn't say that, no.
Okay. Now, let's go back to the narcotics SOPs.
Do you want a copy of that? So you're
I
gonna put it
do.
as an exhibit? All right. Is that the first one? This first one we discussed.
SOPs. That's marked as Exhibit 1. Turn to page 42. Okay, right here in the middle of the page, starting at in preparing the affidavit, middle of page 42. What does that say?
In preparing the affidavit, the officer should verify addresses, conduct surveillance or other cooperation, and take other appropriate measures to ensure accuracy of information.
Okay, now I think we talked about part of the accuracy of the information you guys had, there was a heavyset female alone in the apartment.
Correct.
That was false, wasn't it? It was not accurate.
The alone part would not have been accurate.
There was someone else there.
Yes.
And that, as we already covered, that is valuable information to have.
Yes, it is.
Go all the way down to 2.6.3.1, lead detective.
Lead detective prior to serving.
Yeah.
Are you asking me to read out?
Yeah,
loud, or do you have a
read out
question?
loud. No, read out loud.
Lead detective prior to serving the search warrant. The lead detective may request assistance from the tactical operations team with videotaping the location unless exigent circumstances exist. The lead detective is also responsible.
There was a period there. Okay, so let's stop for a second.
And just to correct the record, he said tactical, it's technical.
Technical, my fault, yeah.
So prior to serving the search warrant, the lead detective, who would be Josh Jennings,
Yes, correct.
may request assistance from the technical operations team with videotaping the location unless exigent circumstances exist. Okay, that's what it says. Now, are you aware of any exigent circumstances that prevented that in this case?
I wouldn't have that information, so no.
What is the technical operations team?
I'm not sure. I don't believe I know what it's saying, but I don't think we have a tactical or a technical operations team. We have a unit that does video surveillance, but I'm not exactly sure what they're called.
Did you see any video surveillance of this location before you went to execute the search warrant?
No.
Now, after the period, it says the lead detective. What's that say?
The lead detective is also responsible for the following. Continue.
Yeah.
Number 1, notification of the supervisor.
All right,
2.
stop. Let's go one at a time. Are you aware if that occurred?
Did the lead detective notify his supervisor? I believe that's obvious from the large group of people that we have there and all the assets that are.
So you believe that occurred based on the briefing and whatnot?
Yes.
Okay, what's the next one?
Completion of the search warrant and risk assessment matrix.
Okay, now, to your knowledge, you never saw one of those?
Correct.
Okay, number 3?
Number 3, completion of the search warrant checklist.
All right, what is that?
The search warrant checklist would be like as it says, it's a checklist to make sure that you have done certain things. As you said, surveillance. It's similar to the matrix. You're compiling some notes and some evidence and whatnot.
So it's a checklist done to ensure, A, that you're executing a search warrant on a proper place, and B, to ensure the safety of the people executing the search warrant.
Yes.
Okay?
No objection, still one question. As the witness already testified, he had no role in obtaining the warrant. Also testified he wasn't the lead detective. False speculation.
No, right. You said yes. You never saw one of those in this case.
Correct.
And then number 4,
Completion of an operations plan.
and as we already covered, you never saw one of those.
Correct.
To your knowledge, one was not performed or was not completed.
Objection. The state's witness's testimony.
I never saw the operations plan.
Okay. And I think we covered too, according to the SOPs, writing on the whiteboard is not a substitution for the operations plan, which has a specific form under the rules.
The whiteboard would not substitute the form that you're referring to.
What's the next one?
Securing approval of the operation plan.
Okay, so that indicates that you have to prepare an operations plan and then get someone to approve it.
Yes.
Okay, are you aware if that occurred?
It's obvious that that did occur with all the assets that are available or that are being utilized that evening. But I don't have information.
Well, if an operations plan wasn't filled out, how could one be approved?
I don't believe there is a timeline as to when the operations plan the form has to be turned in, per se, because these are fluid events. So if I turn in the operations plan right now and my search warrant doesn't happen for an hour, there may be a plan. So now I'm committed to that form that I've submitted previously.
Well, it's required by policy, isn't it?
Yes, it is.
And it can't be done after a search warrant's executed. One of the reasons for it is to protect both public safety and the officers.
I don't know if there's a timeline to when it can be turned in.
It just has to be done before the search warrant is executed.
I believe it has to be done. I believe the form has to be completed.
It has to be completed and has to be approved prior to the service of the search warrant.
This is asking the operations plan, not necessarily the operations form. The form is an administrative form, and that's how I'm looking at it as. The plan would be what I call the whiteboard.
Okay. And again, the SOPs specifically indicate that there's an operations plan form to be used, don't they?
Yes.
Okay. Now, what's the next thing that's required?
Entering pertinent information about the search warrant location into HIDA deconfliction software.
You don't have any idea if that was performed or not?
No.
Okay. And what's number 7?
7, being present at the pre-service briefing.
Okay. And that would be the whiteboard briefing, correct?
I would think so.
Okay. And Josh James is the lead detective, and to your knowledge, he was not at that briefing, was he?
That's correct. That's how I remember it, yes.
And even though this policy says the lead detective is responsible for being present at the pre-service briefing.
Yes.
Okay. Now, move on down to the supervisor will also verify and approve. And go ahead and just start with the phone.
The supervisor will also verify and approve 1, the completion of an operations plan, 2, that all personnel participating in the execution of the search warrant have been briefed, 3, that information entry has been placed into deconfliction software, 4, that all personnel participating in the enforcement action have signed and dated the operations plan.
Let's stop there.
Number 4.
Let's stop there.
No objective line of questioning again. He's not a supervisor. He doesn't have any idea what the supervisors would care about or also speculation.
Okay. You participated in the enforcement action, didn't you?
Objection.
Which would be the execution of the search warrant?
Correct.
Did you sign and date an operations plan?
No.
that all, no, go ahead.
Number 4, that all personnel have their required equipment, i.e. ballistic vests, weapon, extra magazines, handcuffs, OC spray, ASPS, not sure what that is, and ASP, and reflective armbands. Other equipment such as eye protection and tactical gloves may be necessary for the execution of the search warrant. As each situation will be different, it is at the discretion of the commanding officer in charge of the search warrant detail as to whether this equipment is needed. This does not prevent any personnel assigned to the detail to utilize this equipment at his or her discretion.
Okay. And I think we've already covered one of the things that you were not aware of was the availability of the ballistic shield until you guys show up at the door.
Correct.
Now, what's the next paragraph? Prior to serving the warrant.
Prior to serving a warrant, the supervisor in charge will conduct a pre-service meeting for personnel assigned to execute the search warrant. During this meeting, personnel will be assigned to search and entry teams.
Right? And you were assigned to one of those search and entry teams, correct?
Yes.
Right. And then what's the next paragraph?
Supervisor is also responsible for reviewing the search warrant checklist and matrix with the lead detective prior to the pre-service meeting. All personnel involved in the execution of the warrant should be present at the pre-service meeting.
Okay. Now, the checklist and the matrix again we've covered. You never saw either one of those.
Actually, that's the answer.
You can answer.
Correct.
Right? And you never signed and dated an operations plan.
Correct.
All right, go to the next page of the items discussed should include.
Okay. The items discussed should include, but not be limited to, the following: person in charge, location.
Now, you covered the person in charge was Lieutenant Hoover, correct?
Yes.
So that was covered.
Yes. Location, layout of the premises.
Now, the layout of the premises, that was not covered, correct? You had no idea what the layout of the place was when you went there, Judge?
Correct.
Okay. Go ahead.
Layout of the premises, suspect information, weapons, possibility of children present, possibility of disabled persons present, animals present, chemical hazards, environmental hazard, types of odors, fortifications, fences and walls, probable location of evidence, need for EMS, required equipment, i.e. raid jackets, display badges, other identifications, etc., radio frequencies to be utilized, contingency plan. If a detective is seriously injured and a hospital run is required, access route to the closest hospital, alternate breach entry location. This will be noted on the operation plan.
Was that covered?
No. Surveillance conducted prior to entry.
Was that covered?
Yes, we were told that we had a surveillance, that we had Mike Campbell was being the surveillance person.
Was any information from the surveillance conveyed to you?
Not that I remember specifically.
Again, as we said, you believe there was a female there alone?
Correct.
All the way down to the last paragraph here on page 44.
Execution of the search warrant. When executing the search warrant, the lead detective will be in the passenger seat of the lead vehicle in order to lead the search warrant team from the vehicle to the target location.
All right, stop. The lead detective in this case wasn't even there, was it? Josh James
Right.
was the lead detective?
Yes.
He wasn't in the first car going to Springfield, was he?
No, he was not.
He wasn't even at Springfield.
Correct.
Now, you on page 45?
Yes.
All right, let's go all the way down to an officer may break in.
Where do you see that at? Are you familiar with this page?
Not really, no.
If you feel like you need to review the document prior to answering a question on a specific sentence, take your time to do that.
That's okay. What are you reading? Okay.
Right there. Where are we? Page 45. Narcotics, SOPs.
An officer may break into and enter any premises or vehicle when necessary for the execution of a search warrant if number one, the officer has previously announced his or her identity and purpose, reasonably believes that either the admittance is being denied or unreasonably delayed, or that the premises or vehicle is unoccupied.
Number two.
Two, the officer has probable cause to believe that given notice would endanger the life or safety of any person or the destruction of evidence is imminent.
Okay. Now, number two did not, in your understanding, number two did not apply in this situation.
Say that again.
Was it your belief that you all had probable cause to believe that giving notice would endanger the life or safety of any person or the destruction of evidence is imminent? Because you all actually gave notice, correct?
Right, yes.
Right. So two did not apply. That's for a no-no.
Yeah, correct.
All right, so let's talk about number one. May break into and enter any premises if, for the execution of a search warrant, if the officer has previously announced his identity, and you indicated that occurred.
Yes.
All right, and purpose, and reasonably believes either that admittance or being denied. Did y'all have any reason to believe that your admittance was being denied?
I'm not sure I understand that correctly. But denying is the door was not being opened, so that is how I would interpret it.
This might be a good time for us to take a break. So, ladies and gentlemen, it's 5 till 3. Let's take a recess until 10 after 3, and please remember the separation admonition. All right, ladies and gentlemen, anything to report from the break? All right. Mr. Finke?
Knocking the first 2 times and not announcing, and then announcing that entry was being denied.
Yes.
Okay. Now, do you have any role in making the decision to breach the door?
No.
Steve, I realize you're about to get into this new line of questioning. Can you
Go ahead. Yeah, let's take 5.
Off the record, 11:46. Back on the record, 11:54.
When we stopped, we were talking about page 45 of the narcotics manual regarding forced entry into a premises. And number 1 of an officer may break into and enter a premises if the officer has previously announced his or her identity and purpose. And that occurred, we've established.
Correct.
And the first couple of times he knocked and didn't announce. Is that right?
Yes.
And then he announced. Were other people talking during that time?
Yes.
Okay. Who else was what else was going on when he's trying to announce? Other people kind of yelling search warrant, police, or is that when Brett is arguing with the neighbor, or what else? What other noise is going on?
So the timeline, and this is very simplified, obviously. John makes a normal knock, and at some point prior to the forceful knocks is when this other person from above comes out, and then the forceful knocks and the door comes down. That's obviously very simplified.
Okay. So normal knock, no announce. Forceful knock, no announce. Neighbor comes out, argument ensues. More forceful knock with announce, maybe 1 or 2 times, and then hit the door. Is that how you recall it?
Objection.
That's simplified. Yes, that is more or less the timeline.
Okay. So, and I think part of that time you were kind of outside watching the perimeter, which you understood to be your job.
Yes.
Or not understood. That was your job.
Correct.
Who assigned that job to you?
Oh, that I don't exactly remember. It would have been Hoover or John manually.
Okay. But part of this time, you're out a little farther away watching the perimeter sliding glass door, so to speak.
Yes.
And then you realize, he knocks again, neighbor comes out. Sometime around that time, do you realize Noble doesn't have cover?
No, that I only noticed when Noble's had cover was after he'd already hit the door maybe once or twice.
Okay, so he's already hitting the door before you realize he doesn't have cover.
Yes.
And you have to move at that point in time.
Correct.
Okay. And do you know who all is talking, yelling during the time that Brett is knocking? Or not, excuse me, not Brett.
Right.
John. You said other people are talking during that time when you guys are outside the door. And we know there was a time when Brett and the neighbor are arguing.
Yes.
And they're actually yelling, both of them, aren't they?
Yes.
And does Hoover actually get into a yell? Is he yelling as well?
I don't remember Hoover yelling, no.
Okay. So just Hankison's the only one you recall yelling, and then the neighbor yelling back.
Yes.
And they're going back and forth for a little bit of time.
Correct.
During that time, is John is trying to knock and communicate with people in the apartment?
I don't know.
Okay. Is it fairly kind of chaotic?
There's a lot of noise and it's being amplified from this shape of the building. Yes.
Okay. So there's a lot of noise, both from him knocking, him announcing, Brett yelling, neighbor yelling, maybe other people announcing police or whatever.
That is not happening at the same time per se.
Okay.
That is happening over several seconds. It's not happening as in one form.
Not all at once.
The same.
Yeah.
45 seconds.
And that was just his perception.
Correct.
But all of him yelling, police, search warrant. Did you ever yell?
No.
Okay. Did you hear other officers yell?
Yes.
Okay. You don't know who, you just know they're yelling.
Correct.
Right? And you've got Brett yelling not at the door, but at the neighbor. You can answer.
Yes. Yes. Brent is having a
shouting
verbal exchange with this guy.
Is it a shouting match?
It is, and I believe I explained it as the guy is being somewhat belligerent to Brent and questioning his verbal directions.
Okay. The neighbor's being, not neighbor, but the guy's being loud.
Yes.
And did you hear his act? Is he hard to understand?
I am not able to understand what they're saying due to the distance. All I hear is loud shouting back and forth.
Okay. And other officers are yelling police or search warrant or this is the cops or whatever.
I don't believe anybody was yelling police search warrant during this verbal exchange between Brent and the upstairs guy.
Okay. But there came a time when not only John was yelling police search warrant, or did he yell search warrant until the door was breached?
I don't know exactly what everybody says, but you would say police search warrant or search warrant. Police come to the door. So a verbal directive of police would have been given or was given at the door.
Okay. And multiple people are giving it?
Yes.
And does that make, because you've actually given a statement that you didn't talk because when multiple people talk, it makes it hard to understand.
Yes.
And multiple people are talking in this, outside this door.
They are giving loud verbal directives, yes.
Different people, and they're not like all saying 1, 2, 3, let's yell search warrant. Everybody's talking at a different time.
Yes.
And saying different things.
Yes.
Making it hard to understand.
Objection.
I believe they're making it very clear by their loud voices what they're saying.
Did you ever hear anyone from inside say, "We're not letting you in"?
No.
Denying entrance.
No, I heard no one speaking to me from inside the building.
Okay. Moved into position yet?
It could have been due to the distance, yes.
Okay. Once you're aware that if someone is yelling, who is it? Is it reasonable to actually tell everybody, hey, shut up, let's see if we can communicate with this person? So you don't have to bust the door down?
Yes, yes.
Okay. Once somebody says, hey, who is it? Rather than everybody yelling at once, somebody should communicate with them.
Correct, yes.
Now, is that something that is covered in a search warrant briefing or the parking lot?
Communicated? No. that would not be formally communicated. It would be, like I said, police work is fluid, so if I can hear a person and I'm on the back side of the building, I would want to communicate that to folks who are on the front side of the building. So that wouldn't be an assigned job per se. You would set yourself up for failure if you did that.
Okay. So there's not one person that's supposed to talk and try to make contact.
Can you clarify that a little bit?
Yeah, but what I'm at is, if everybody's yelling at once, it makes it much harder to understand.
Yes.
You agree with that?
Yes.
Is anybody assigned to, I'm the guy that's going to be knocking and yelling, everybody else be quiet so they can understand me?
I don't believe there's a formal assignment, but if you're the person standing at the door, you are the person who is going to be knocking and announcing. That would be logical.
Right. And so that person knocks and announces, and everybody else shuts up, so maybe they can understand what's going on. Objection is answered. Which is what you did, actually.
Yes.
Right.
Yes.
But everybody else didn't. Everybody else is talking. You're being quiet, but other people are yelling.
No, well, John's initial light knock. I'm not sure I understand I don't understand the question. So there's a there's a timeline that's happening here. So this isn't a continuous knocking. There are gaps here, so people can communicate with us, and we can communicate with folks.
Okay. And what I think I'm trying to ask him, I think we've covered it, but nobody is doing John's not doing the only talking. Other people are talking and yelling and trying to communicate.
Yes, other people are giving.
Get back into this. Did you see after the shots were fired, Mangley returns fire, you return fire, did you see a pile of men in the parking lot when you came out?
I will object to form just because I don't understand the question.
Okay.
Yeah,
After you fired the shots and you retreated to the parking lot, did you see a pile of men laying on the ground?
At some point, I wouldn't describe it like that.
Okay, how would you describe it?
From which part of the timeline?
Okay. Well, were there any other times that you saw a group of men laying on the ground?
What do you mean by laying on the ground?
Well, from the time you guys arrived at Springfield to execute the search warrant until you left with peer support, was there any time in which part of your team were on the ground?
Yes.
All right. What was the first time?
The first time that I saw someone on the ground, laying on the ground, in a prone position would have been Mike Campbell, probably. Would have been the closest person I saw to the laying or in a prone position.
Okay. And where was that?
In the, what I call like the T intersection there of the sidewalk and the apartment walkway area, breezeway.
Towards the curb of the parking lot?
Yes, the curb.
Okay. And when was that?
That was as we were retreating, like you said.
Who else did you see on the ground? Did you see anybody else either fall over Campbell or be beside Campbell on the ground?
So Campbell is on the ground, and that's when, and I can't specifically identify people, but that is when most of the folks that were in the vestibule area kind of bulldoze or walk over Mike Campbell.
Okay, so the people that were in the vestibule area are retreating. And that would include you.
Yes.
Sergeant Mattingly.
Correct.
Hoover. Nobles.
Yes.
James.
Yes.
And Hankison?
Now, I am not able to identify any specific person other than John and Mike Campbell. I can't identify anybody else than them precisely.
Okay. But you saw both of those two go to the ground.
Mike Campbell is on the ground, and John is scooching, shuffling. You know, he's not on the ground. He is moving over Mike Campbell.
Okay. Do you see him fall over Mike Campbell?
Not necessarily fall, just kind of bulldoze over him, and then they're out of sight.
Let me start. What do you mean by bulldoze over?
Well, Mike Campbell is a fairly large man, and behind Mike Campbell is the parking lot cars, so that is a confined space. So you can't fit Mike Campbell and other bodies through this confined space without there being some type of tripping or falling or stumbling or however you want to call that.
Okay. So trip, fall, stumble, bulldoze, whatever reason, Mattingly goes over Campbell and goes to the ground.
I don't know if I can't identify specific people, but people more or less go over Campbell to get through the parking lot.
Okay. Does other people fall?
It is just a mass of people moving over Mike Campbell. Okay. And at the same time, I am also moving as well. So I'm not able to give great detail as to who's doing what and whatnot. I just see men falling and tripping and are moving forward.
Okay. Now and you guys are retreating from the apartment. Are you trying to go backwards, or you turn and have your back to the apartment?
I am moving. Well, I want to say I am moving away from the apartment. Say that again. I'm sorry.
Okay. Yeah. As you're retreating from the apartment to the parking lot.
Right.
Everybody else is retreating also?
Yes.
Okay. Are you running with your back to the apartment, facing the parking lot, or are you backing out, still looking at the apartment?
No, I am facing the parking lot and moving towards the parking lot.
And that's how you see Campbell,
Yes.
Mattingly, anybody else trying to get
Correct.
over the top of it.
Yes.
And you may have been, do you observe anyone else actually go down, or are they just scrambling over the top of him, or how exactly does that happen?
I'll use your word, just scrambling, moving forward, just a mass of people, unidentifiable people moving forward, scrambling.
Okay. Is anyone shooting at the apartment at that time?
I believe I said that I am able to see flashing while I'm moving from the vestibule to the parking lot.
Okay.
But, so yes, I'm able to see flashing lights.
Okay.
Flashes.
You don't, at the time, you do not know either if that's one of you guys providing cover or someone else shooting, or do you?
I don't know.
Okay. At what point in time did you say, unfuck yourself and reload?
That was during the reloading when we were all in cover.
So after you all get to the parking lot, scramble, fall, whatever, you're kind of in cover.
Yes, we're behind the parking lot. We're behind the parking lot cars.
Now, is someone still out in front of the cars returning fire into the building?
I don't know. I don't think I ever said anything like that.
Okay. So at what point in time do you recall the shooting stopping?
I'm not sure I'm able to, I put an exact timeline on it. I know that I saw those flashes of lights as I'm moving through those, or just prior to moving through those cars into the parking lot.
Did anyone ride with you from the station to St. Andrew's Church?
No.
Okay. Did anyone ride with you from St. Andrew's Church to Springfield?
Yes.
Who was that?
Lieutenant Hoover.
Okay, and his car or truck was left at the church?
Presumably, yes. I'm not sure how he got there.
You don't know how he got to the church?
Correct.
All right. Now, when you left the briefing at the station, where did you go?
I went to the church.
Went directly to the church from the station?
Yes.
Did you go by Dixie Highway, anywhere out on Dixie Highway?
No, I don't believe so. I don't know that area that well. I would have gone right to that location.
Do you recall who else drove from the church to Springfield?
No, I didn't. We didn't. What's the word? We didn't caravan over there, follow each other over there. So
Did
I
not?
don't know. Correct.
Okay. Everybody just kind of went separate and arrived when they got there?
Yes.
Was that part of the operations plan or the briefing?
To meet at the church, yes, not transportation to the church.
Okay, so getting from the church to Springfield wasn't something that was covered?
Yes, it was covered at the church.
Okay. And how was it covered? You're not going to caravan, just everybody get there when they get there, or how did that work?
Objection misstates his testimony. He said that there was no plan to caravan from the briefing to the church, not from the church to Springfield. Answer the question.
Correct. There's no plan to go from the church to or from the office to the church. There's no plan, but from the church to the location, you want to minimize as many vehicles as you can.
And all get there at the same time?
Yes.
Okay. And so you all followed each other?
Yes.
And?
To the church, or you're killing me here.
I got you.
To Springfield, yes.
Yeah. And someone rode with you?
Right, Hoover, yes.
Hoover rode with you. Did anyone ride with Nobles?
I don't know.
Did he have anyone else in his truck?
I don't know.
Do you recall how seeing Cole Gibson there?
Yes.
Who is?
No, not at the church, no.
Okay, at Springfield?
Yes.
When do you recall seeing him?
My sense of time when Cole got there, that was after SWAT got there, so sometime after the event.
Did you talk to Detective Gibson?
Yes.
Okay. Was he your peer escort?
Informally, I would say yes. I hadn't heard the term peer escort, so that night So Cole would have been informally, I think, my peer at school.
Clip on his tack vest.
Right.
Where did you keep the actual cameras?
What do you mean? The camera is kept on your person.
All right.
The clip, that's where it's kept.
It goes on the clip that's on your tack vest, is that right?
Yes.
And if you're not wearing a tack vest, where does it go?
It can go in various places, and on the dock, and your desk, it can go in various places.
On your lapel,
Right.
anywhere you want to wear it. Right? Now, it was removed from your tack vest that night, is that correct?
No.
It was on?
No, I didn't have a camera on there.
Okay. So if there's a place for it on your tack vest to mount, it was not in that mount, correct?
Correct.
Had it just never been on that tack vest, or was it removed from it?
The camera wasn't with me that evening.
Where was it?
To the best of my knowledge, it was in the car or in my desk.
Were you in your car?
That evening, yes.
Okay, so if to the best of your knowledge it was in your car, then it was with you that evening.
Objection to the formal question.
The car was either in my desk or in the car or somewhere, yes.
But you never looked for it?
I don't remember looking for it, correct.
Because you were not going to wear it?
Right.
It was that you recorded on the day before with your body cam.
No, I have no idea.
Okay. Would it have been your work as a law enforcement officer?
Probably.
Okay. And do you do other law enforcement work other than narcotics at that time?
I'm a policeman, so I could pretty much do almost any job that they ask me to do.
Were you doing other jobs on March 11th, or were you doing narcotics work?
I don't know exactly.
Because if you're doing narcotics work and you're recording and downloading video on March 11th, the day before, you obviously understood that narcotics use their body cameras.
Yeah. I'm not disputing that. That's correct. I'm aware of yes.
And was there if narcotics used body cameras, if they were issued, and it was used the day before this raid, what reason was it not used for this specific search warrant execution?
I don't know. What are you looking at right here? Okay, my fault. Go ahead. I thought you were looking. Okay. CID was created combining other pre-existing investigatory units, narcotics and 9th Mobile.
Keep going.
The operations manual for CID was revised on July 1, 2020. There was not an operations manual for the unit prior to this, so I examined previous operations manuals for the narcotics unit and 9th Mobile. The 9th Mobile operations manual does not discuss use of V or WVS. Additionally, the 9th Mobile detectives were routinely issued the equipment and were obligated to use the equipment as directed by LMPD policy.
Stop for a second.
Were you ever part of the 9th Mobile?
No.
Okay, go ahead.
The operations manual for the narcotics unit from the effective date of July 18, 2019, addressed WVS with little variation to LMPD policy. There are no additional prohibitions listed for the use of the equipment specific to the covert nature of the investigation.
All right, stop. So at least according to this report, there is no, and let's use the exact language, the operations manual for the narcotics unit addressed WVS with little variation to the LMPD policy. Okay? Now, do you dispute that?
Yes, I do.
Okay, and what do you base that on?
I base that on my experience in the years I was in narcotics.
Okay. Is anything specific to the policy, or just that's how you did it?
Both, probably.
Okay. When had you last reviewed the narcotics operations manual, SOP?
I have no idea.
So you aren't particularly familiar with it on either in March of 2020 or today?
No, I'm familiar with all of the policies. I just hadn't, I don't know when the last time I reviewed it would have been.
Are you aware of anything in the narcotics policy that exempts you from having to use a body camera if it's assigned to you?
I don't have that policy in front of me, but I would say there are exemptions. Yes, there are. There would have to be.
Well, we looked at it earlier. It's exhibit.
This is not the narcotics policy, though.
That is.
Okay.
And are you familiar with anything in the narcotics policy that exempts narcotics officers from using WVS if it's been assigned to them?
I mean, I would have to go through this whole thing, but there has to be exemptions of using a video recorder for the work we do.
You don't know what it is, you just think there has to be one.
There has to be one.
Okay. The part of a policy that exempted narcotics from wearing WVS.
There would have to be one.
Okay, but you don't know it, you just think there was one.
Correct.
Because nobody did.
I'm not sure about that. I would say there has to be a policy on when you can, when an appropriate time would be to wear the video system.
You just not familiar with it.
I can't remember the day.
Okay. And as we talked about initially, these policies and SOPs are put in place as best practices.
Yes.
Right? And they can be deviated from in a limited number of circumstances.
I would agree, yes.
Right? One of them is exigent circumstances,
Yes.
public safety,
Correct.
if something in it's not addressed by the policies.
Correct.
Right? Other than that, you're supposed to follow them.
Correct.
And they are designed, one, not only for officer safety, but public safety as well.
Yes.
And choosing to ignore one just because you think there might be something that allows you to can be dangerous, can't it?
Object to the form of the question.
Can you say that again?
Yeah. Choosing to ignore a policy just because you think there's a reason you can without knowing anything can be dangerous, can't it?
Object to the form of the question.
It would be inappropriate, yes.
And much like if these people doing the search warrant operations plans, they just said, I don't think I have to do that. It doesn't really apply to me. That puts you in danger when they don't do what they're supposed to, doesn't.
Objective form of question.
It could complicate situations by not following that form, yes.
The procedures are in place for a reason. And ignoring them or disregarding them makes inherently dangerous situations more dangerous.
Objection.
Department without positively identifying it, correct?
All right, stop for a second. Are you trained in the academy about use of deadly force?
Yes.
Target identification?
Yes.
Being responsible for every shot? You're accountable for every shot?
Yes.
Do you agree that you shot 16 times that night?
I have been informed that I fired 16 minutes.
And I've read you at the time had no idea how many times you shot.
I was under the impression I fired 4 rounds at the time.
Was there a time in which you had a positive target identification on the shot that was fired at Sergeant Madden?
I have clearly, over various interviews, clearly explained what I was shooting at.
And that was a shadowy figure?
That was a deadly threat in front of me that shot at me, correct?
Well, and again, I don't want to go too far into this. The individual that was killed did not fire a gun at you, correct?
Correct.
And did you ever actually see a gunshot be fired at you?
Yes, I did.
Okay. Where were you when you observed the shot being fired?
In the threshold, the frame of the door. Not in the frame of the door, but within the frame of the door.
And Sergeant Mattingly was in front of you in the frame of the door?
Correct.
And you were right behind him in the frame of the door?
I was behind him, yes.
Now, is that, moving back to the briefing and the planning, is that how you guys were briefed into execute the search warrant?
No, like we discussed earlier, the plan changed due to seeing the Mike Nobles didn't have a cover person.
Somebody either didn't get assigned the proper role to cover Mike Nobles, or they didn't do their job.
Objection. Asking answer.
Mike Nobles, correct, did not have a cover person when he was working.
Right. And again, that would be something that has to be assigned.
Yes.
And at least either it wasn't done or somebody didn't do it.
Same objection.
Correct.
Right? And so you took that responsibility.
Yes.
Now, are you trained for both of you to be in the doorway at one time?
Well, when you say in the doorway, as we all know, a doorway is a small space. You can't fit 2 men side by side into a doorway. You stagger each other like a roller coaster or a train car.
Okay. So, and would that be what is called in police work, I guess, the fatal funnel?
Correct. A confined space would be the fatal funnel.
No. Was it your all's part of the briefing and plan for both of you all to be in the doorway at the same time?
How else do you get into a doorway without standing in front of the doorway?
Okay, apologize. The part of the planning was for both of you guys to be in the doorway at once.
Object form.
You can only fit so many inches within a doorway. Maybe I'm not understanding your question.
No,
you can't walk two people through a door. Is that what you're asking me?
No, I'm saying, was that how it was planned? You guys both being in the doorway together, was that part of the plan of breaching the apartment?
How else do you get multiple bodies through a doorway if you're not standing in the doorway?
Is that a yes?
It's common sense. You have to form a line to walk into a door.
Okay, and so are you saying that was part of you and Mattingly both being in the doorway?
That's not a plan. That's common sense.
Okay, well, and again, when you're executing the entry of an apartment, we do all of these things as required by policy to plan that out, correct?
Correct.
So there's not mistakes that happen, and both the public and officers aren't put in unreasonable danger. And that plan includes how entry is made, who goes in, when they go in, and how that is done, correct?
Yes.
Was part of that plan for Mattingly to go in first, you be staggered behind him also in the doorway?
Initially, no, that was not, to my knowledge, that was not the plan, no.
Yeah.
Due to my assignment, yes.
Yeah, well, and that's what I'm trying to get to is, it was never planned for you and Mattingly to both be in the doorway.
Yes, correct.
In the briefing, at the church, none of this is ever part of a plan.
Do you have a formal question?
Correct. There was not a formal plan. Yes, correct.
And all of those, through no fault of yours, were supposed to be done before you're in that situation.
Object to the formal question. Can you check you understand what he's asking?
Yes, there was a plan prior to me moving forward.
Actually, I think, what was my last question?
And all of those, through no fault of yours, were supposed to be done before you're in that situation.
That being who goes in, who makes entry, who goes in first, who goes in second, who's covering Nobles, who's covering Mattingly. All of those were part of, or supposed to be planned out.
Yes.
Okay. None of that was actually done and planned out ahead of time by whoever at the station or whoever at the church.
Object. The state's testimony.
No, there was a plan from the church to the parking lot, or from the church to. We had the plan, the operations. See, now I'm confusing myself. You're confusing me. We had our church parking lot operations plan with individual signs.
Okay. And whose assignment was it to cover the ramp?
I don't know.
And again, I don't mean to beat a dead horse, but that is one of the most important roles.
Objection. Answer, of course, is dead.
Cover for
Yes,
the ramp.
Mike Nobles' job is the cover person for Mike Nobles' job is an important job. Yes.
That has to be assigned.
Yes.
And to your knowledge, it wasn't assigned.
I don't remember if it was or not. Yes, correct.
And your assignment was to cover the perimeter.
Yes.
So in back to what I was asking of, part of the plan, you were never supposed to be entering the doorway together with Mattingly, were you? You were supposed to be watching the perimeter.
That's a hard question to answer because plans change. But to answer your question, if plans go exactly how they're supposed to go, then the answer would be yes.
And by the same token, the entire plan, if you have a ballistic shield, that's supposed to go in first before anybody.
I'm not an expert on the ballistic shield, but from my training experience, yes, the ballistic shield should go first.
And had anyone, or at least you, been aware that there was a ballistic shield available either at the briefing at the station or at the church briefing, you would have said, hey, how about the ballistic shield guy go first? Or would you have said that?
I think that would have been implied.
Yeah, it just, everybody knows that's supposed to go first, don't they?
Correct.
And in whatever briefing and whatever plan that was set up to go into this apartment, nobody ever knows until you're walking up there, oh, we've got a ballistic shield.
I didn't know until we were walking down.
And it upset you.
Yes, it irritated me.
Because, again, that changes everything, doesn't it?
Yes. Ask and answer.
Yes.
Now, turn to page 50. You do police-related activities, wouldn't it?
Depending on what I'm doing in that unit at the time. I wouldn't want to wear a body camera while I'm interviewing a confidential informant. That's one example.
Well, are you aware if there's a specific exception in the body cam policy for confidential informants?
I would hope so.
Yeah, there is, but is there any other examples other than confidential informants that you can think of?
I'm sure there are, but I can't think of anything right now.
Let's take a break, about 5 minutes.
Back in the record at 140.
Mr. Cosgrove, I'm handing you what's been marked as Exhibit 8. We're talking about we've already looked at Exhibit 1, the narcotics manual. That's the SOP regarding narcotics investigations. I'll look through there and see if you see anything that addresses body cams in that, or exemptions for body cams. To knock and announce. Who made that decision?
I don't know who made that decision, but that's what I was instructed to do while in the briefing room at the office.
That at the headquarters or station,
Correct.
They said knock and announce.
Yes.
Now, did you determine that to be an order that you could not deviate from?
You could deviate from that, yes, but based on what I was told, the totality of it, the female that had set the direction that I was given on the board, you could deviate from it for reasons that we would determine while on scene, such as like some kind of exigent circumstance, somebody needing immediate help or something like this, just some extenuating circumstance.
Okay. Now, if someone needs immediate help, you don't even have to have a search warrant, do you?
Correct, and that's why I kind of stumbled over myself there.
All right. But if you are going to the if you have a knock and announce warrant, okay, you're not allowed to just go in and no knock, are you?
No.
You have to knock and announce. If you have a no knock warrant, you can go in without knocking, or you can choose to knock.
Yes.
All right. Now, however, if you have a no-knock warrant, SWAT is supposed to do it, correct?
I believe so.
Yeah. And so, simply because you have a no-knock warrant and you decide, oh, we're going to knock and announce, you don't get to go there and change your mind all of a sudden because SWAT's not there.
Objection to the formal question. I want to further object because this witness has already testified that he was not a part of the decision making. And to the extent there are any questions about the risk assessment matrix, he's already testified that he wasn't involved in the creation, preparation, or submission of that document and never even seen it.
And you wish you'd have seen it, don't you?
It would have been helpful.
Question.
An accurate risk assessment matrix would have been very helpful, wouldn't it?
Yes.
But back to the question I was asking, if you have a no-knock warrant and you're briefed that we're going to knock and announce, and just you guys, CID guys, go, absent something, somebody inside being at risk, you guys aren't allowed to just say, no, we're going to go in as no-knock, because SWAT is not there, correct?
Correct, unless there's some new mitigating circumstances that would make it, or would go back on the original no-knock. Correct.
All right, the Commonwealth's next witness.
Your Honor, first and foremost, that's the end of the clip, and at this time I would move to admit it's going to be Commonwealth's Exhibit 155, which are all 16 clips together on this USB drive.
Any objection?
No, Your Honor.
All right, it'll be so admitted.
Commonwealth calls Chelsea Napper.
If you'd raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can take your mask off while you're testifying if you wish, but you're not required to.
So state your name and spell it, please.
Chelsea Napper, and it's Chelseey. Last name too. Napper.
And if you would speak up so we can hear. And do you live in Louisville?
Yes,
Did you grow up in Louisville?
I did.
Did you go to high school in Louisville?
I did.
Now, do you live with Cody
I would say a little over 6 years. Or actually a little under 6 years, sorry. Or no, a little over 6 years,
Little
sorry.
over 6 years.
Yeah.
Do you and Cody have children?
Yes.
And who are they?
I have an older son named Zayden, and we have a 2-year-old together named Bryson.
Now, you said Zayden is your son.
Right.
When you met Cody, did you have Zayden had already been born?
Not when I met him, but me and Cody have known each other for a long time, but I had him before Bryson.
And did you always have custody of Zayden?
I'm sorry, before me and Cody were together, I meant to say I did have Zayden.
And did you always have custody?
Yes.
Now, Bryson was born when? You're and Cody's son.
June 3rd, 2020.
So in March 12th specifically, you were pregnant with Bryson?
Yes.
How many months pregnant?
I would say about 7 months.
And where did you and Cody in March of 2020, you, Cody, and Zayden live?
In St. Anthony Garden Apartments.
And what's that address?
3003 Springfield Drive, Apartment 3.
Ms. Napper, I'm going to hand you 2 photographs marked Commonwealth Exhibit 156. And what does that photograph show?
This was right after Bryson was born. Well, I would say a couple weeks after he was born. We went to Cody's grandma's to just visit.
And that's you, Cody, Zayden, and Bryson.
Yes.
Is that a fair, accurate representation of the family?
Absolutely.
I looked at it, Exhibit 156 at this time.
Any objection?
No, Your Honor.
All right, it'll be so admitted.
Now, 157, and you this photograph. And who is that?
That's Zayden.
That's Zayden?
Yep.
And is that when was that taken, that picture?
This was, I would say, in 2020.
And is that a accurate picture of your son?
Yes.
And so we move to admit Exhibit 157.
No objection.
It'll be so admitted.
How long had you all lived at 3003 Springfield?
Over a year, but less than 2 years.
And what was your apartment number?
Apartment 3.
Now, I want you to, we're going to put a photograph on the screen behind you, which Commonwealth has already been admitted as Commonwealth Exhibit 71. And is there a laser pointer up there?
I don't see one. Thank you.
You would take a look at this overhead, and as you see the building 3003 designated up there. And can you just point to it with the laser? Now, generally, when you all would come home to your apartment 3 there, how would you enter the complex here? Would you just take us on the route that you would come in?
Well, so if you go up the road, like it would be over here, down this road, there's a main road like over here. You go up and there's an entrance that it's not really shown in this picture.
So how would you come in from the lower road or the road right?
There was a gate that blocked this. So we would have to come into the main entrance of the apartments, which would be this
That way?
we would take.
And because the gate was locked.
Right.
At that time in early March of 2020.
Yes.
So did you have a particular parking place that you all used?
Not like one specific, no, we just parked.
So those buildings that are on at what we're looking at, the lower road there as you're coming in, those apartment buildings are right across the street then from your building?
These?
Yes.
Yes.
Okay. Now, did you, at that time, were you working?
I just lost my job from COVID.
Because of COVID?
Yes.
Because actually, that's right about the day that COVID hit.
March 6th is when I would say the majority of people were either laid off or sent to work from home. And that's so about a week before this happened.
And again, if you could speak up just a little bit. And was Cody working?
Yes.
And what hours did he work?
I mean, he left really early in the morning, of course, Monday through Friday, but he did a lot of, working overtime at night and on the weekends.
Now, if you would look at Exhibit 76, which has been admitted, and that's behind you again on the screen, and point out where the front door is of your apartment, and then the bedroom that you and Cody used, and the bedroom that Zayden slept in. And then specifically in the bedroom where Zayden slept, where was his bed?
His bed, so the pillows were right here, but it would go long ways, just like that.
So the pillows were on that wall, that common wall with the living room then.
Right.
And the doorway then from your and Cody's bedroom was right across from the doorway to Zayden's bedroom.
Right.
As we see there. Now, you said you had lived there about 2 years in the building?
Yes.
Did you know the neighbors as you're standing in your front door to apartment 3? Apartment 4 would be directly to your left if you're facing the parking lot. Did you know the folks that lived in apartment 4?
I didn't know them, but I passed by with them.
And who would you?
Are you asking? Go ahead, sorry.
Well, did you know their name?
No.
And how many people were there?
I would say 2 females, and I saw 1 female with a younger child quite often, and then maybe 1 male.
Now, you saw a male that was actually living there, you thought? Or coming to visit?
Honestly, I didn't think too much about it to know whether he was living there or not.
Okay. And how long had you been seeing the male?
I knew 2 females lived there for a fact.
Okay.
I don't know. I couldn't put a
I can't hear you once again.
I couldn't put a time on it. I just seen him in passing. I didn't know, if he lived there or not. I couldn't tell you if he had a bedroom or if he lived.
Okay. So did you know any of the other neighbors, such as as you're facing looking into the breezeway, to the left of your apartment would be apartment 2, Did you know those people?
I did, in the back, so 1, 2, she was an older lady, yeah, I knew her.
So her doorway was right next to your front door.
Right.
Then her, because would you point out your patio there at the back? So was her patio right next to yours?
Yes.
And then did you know the people in apartment 1?
I mean, if they were in a crowd, I could point them out, but no, I didn't know them personally.
What about any of the 4 apartments upstairs? That would be the number 5, number 6, number 7, or number 8.
No, I didn't know them.
You didn't know them. Now, on March the 12th, what were you and Cody and Zayden doing that evening?
That evening, I didn't have, I remember we did, we colored in a coloring book and just pretty much took it easy. We went to bed fairly early, I'd say about 10:30, and...
You all were in bed then, 10:30? Yes. And Zayden was in bed?
Yes.
And Zayden was in his bedroom?
Yes.
In his bed?
Right.
Now, first of all, are you a light sleeper or heavy sleeper?
I'm a very heavy sleeper.
You've always been that way?
Always.
What about Cody?
He is a very light sleeper.
And how about Zayden?
He's a heavy sleeper.
He is a heavy sleeper. Once again, I'm going to have to ask you to speak up.
I'm sorry. He's a very heavy sleeper.
So were you all asleep after you went to bed about 10, you said, and were you asleep?
Yes.
What happened that woke you up?
About 12:40-ish, I feel like me and Cody both jumped out of bed at the same time. It was extremely loud. It felt like, I don't know, somebody set off a bomb or something.
What did you do?
So he took off, and
Who is he?
Cody took off down the hallway, and I just froze for a second. And then I think he said that our apartment is getting shot up. And so he either said something about Zayden, or I don't remember exactly, but I went to check on Zayden, and I felt on him because he said there was bullets flying everywhere. So
Cody said that?
Yes. So I felt Zayden and made sure he was okay, and I walked out of his room and I went to the hallway because I was too... So I go and I check on Zayden. I walk out of the hallway because I was too scared to go past here. So Cody told me, get Zayden, get on the ground, and I got Zayden, I got on the ground.
So point out where you got on the ground.
I got Zayden, and we got down here once everything was fine. The noise stopped. I walked out and I sat down here on the ground. I called my grandma. She said that she really couldn't understand what I was saying, and told me if it was an emergency to call 911. So the reason I called my grandma was because first of all, I had just jumped up from sleep, so I was kind of, and I knew that something bad was happening, and my first instinct told me that I needed to get Zayden out of the situation. Whatever it was, I had no idea what was going on, but I felt like Zayden needed to be picked up. So I called her. Like I said, she said she couldn't understand me, told me to call 911 if it was an emergency. So I called 911. She said, she kind of asked me what was going on, and I told her all I knew. Our apartment was being shot up. There was bullet holes all through the walls, and she assured me that the police were on the scene. And then I later found out they're the ones shooting up.
Okay. Have you had a chance to listen to that 911 call?
I have.
And does that sound like an accurate representation of what you said when you called 911, the first time you called?
Yes.
We would move to admit Exhibit 158
No objection.
Will be so admitted.
and play the 911 call. So that was the first time you called 911?
Yes.
And they told you to stay in the apartment?
Right.
Now, you had seen the glass all shattered on your back, your patio door. Was it cold that night?
Freezing.
So were you, I guess the air was coming in then through that door.
Yes.
So what did you do?
From there, from the 911 call, or
Yes.
about the freezing? So that was the first call. A little bit of time went by, and that's when I heard somebody. It was the neighbor in apartment 3, or no, apartment 4. I'm sorry, and it sounded like, to me, it sounded like a kid. I thought a kid was crying over there. I didn't know what happened, but they kept saying help, and I don't know if it was breathe or something. And I told Cody, I said, there is a child over there, and I think you need to go get the child. And I don't know if he was, at some point in time, he tried to go out he opened the front door. The layout's gone, and they yelled at him really loud to get back in. And I can't remember exactly how each thing happened, but I know when he tried to when the glass was falling down, he pulled the blinds to, I don't know why he did, and there was a bunch more officers out back holding lasers and guns on him. There was a dog telling him to put his hands through, like there was a bullet hole in the glass door, and right underneath it was a really big hole.
Yeah, if you want to go ahead and point to where that, you said he was putting his hands out, Cody was?
No, he didn't put his hands out. They directed him to put his hands out, and he wouldn't do it. And I told him, it was just so scary and crazy. I didn't know what was going on. They were screaming at him through the back door, and his adrenaline started. He's telling me to call 911 again. They got the wrong apartment, he said. And so that's the second call that I made. And I remember telling him, I'm like, you better get the back here because they're going to shoot you, is what I said.
Okay, so you called again to 911.
Right.
And have you had a chance to listen to that 911 call?
Yes.
And is that, as you remember it, what you heard on the recording, what you remember saying on that call?
Yes.
Would move to admit, play Commonwealth's Exhibit 159.
No objection.
It'll be so admitted.
3003 Springfield Drive. Yes. Is that a house or an apartment there? An apartment. What's the apartment number? Apartment 3. Apartment 3. What's your name and phone number? Chelsea. Number 502-341. What's going on there today, Chelsea? I don't know if they have our apartment confused with whatever is going on, but they're telling him, they're pretty much holding him at gunpoint, saying, get out of the window, our apartment's got bullet holes through it. My son is in here sleeping, and I need somebody to let them know, like, that we need help in here. I don't understand what's going on. Is there somebody inside of your apartment? Me, my boyfriend, and my son. So and the dog. Who's inside of your apartment with the gun? Nobody. I'm saying the cops are like through the apartment next to us. And they were really aggressive when we tried to open the door and figure out what's going on. And I don't know what's going on, but just stay inside of your apartment, okay? Okay. Okay. But we just see him at the door, and they held him at gunpoint. They held who at gunpoint? My boyfriend. They told you what?
The police, I went to the back door. The bullets came through the front wall from the next apartment where the shooting happened, through our wall, and hit our back screen door. And I went to the back screen door just now, and there's police back there with the flashlights, and they're telling me to put my hands out the fucking window.
I'll call over to the dispatcher and let them know. Just stay inside of your apartment, okay? Don't go outside.
All right.
So once again, they told you to stay inside.
Yeah.
Did you, at some point, the officer come to the door and explain to you all what had happened, or did they come and take photographs?
During everything, I had no idea that it was the police. I thought somebody had gotten a fight in either the parking lot or in the neighbors, or something happened. And when I think that it was either an officer or a detective that came in hours later and asked to take pictures. And I asked the officer if the holes were from the police, and he told me, he said, he kind of just shrugged his shoulders. He was like, I don't know.
So they took in, did they collect the two bullets that had, one bullet on the dining room table? Did they collect that?
Yes, and I think there was also one on the living room floor.
By the shattered glass door? And the bullets that came through, they damaged that dining room table.
Yes.
Now, at some point, did you try to do something about the fact that the sliding door was now gone and the cold air was making it very cold in there? Did you?
So, once, I don't know, daylight came, I opened the door, things had calmed down, and, I mean, I wouldn't say calmed down, but to the point where it was getting freezing in there. Zayden was getting ready to wake up. I kept opening this door. Okay, so the breezeway is right here. And I tried to go out and talk to the landlord because she wasn't answering the phone. I didn't even know if she knew what had happened or anything. And there was an officer standing in the breezeway saying that we couldn't come outside. And it was a crime scene, that nobody could come outside. You would have to use the back shattered, I guess, walk through glass is what she wanted us to do. I have no idea. And so I kept going back in and kept trying. Finally, I guess they had the cones out there and they did everything they needed to do. And I walked up that hill you've seen that I drove through, because I couldn't get a hold of her on the phone. So I took Zayden, and mind you, the door to apartment 3 or apartment 4 is wide open, where a body laid for hours and hours and hours. And I had to block my 5-year-old son, who is wondering, I guess I don't even know what I told him had happened, but I tried to keep it from him forever. And
so you walked where? There's the overhead again, if you want to point to where's the office is.
I walked up this way. All this was blocked off, so I walked this way, and I walked up, and I walked to the landlord's house, to the landlord's office, and tried to get like a shop vac to suck the glass up, or the door boarded or something. I don't know what I was trying to do, but something.
And did they help you out?
It took a long time. They came and put boards on it that evening, and then it stayed that way for quite a while.
Now, that was your furniture in the apartment.
Yes.
You own the furniture. So at some point after all this happened, did you talk to a lawyer about suing the police?
Well, I remember taking a little bit of time, and I think that there was some officers who were there the next couple of days. One of them actually lived in that apartment complex, and we were talking about it, and I learned that it was in fact the police that shot through our apartment. And I was just thinking, looking at the table, dealing with my 5-year-old who's got all these questions, saying he wants to grow up and be I picked him up from his
Judge, I'm going to object at this point. That's not responsive to the question that was asked.
She's explaining how she let her continue with this. Well, did you call the police about the damage to your property?
I called Louisville Metro Police Department and asked them if there was a way I could hold someone accountable for their actions because of the questions I was dealing with out of my 5-year-old. My furniture was ruined. My clock was shot. I just threw it in the garbage. And they gave me the number to the Kentucky Bar Association.
So you called first the Louisville police,
right,
and asked them how you could be compensated for this, the furniture that was destroyed and so forth.
And not to mention they could have killed.
And so,
I'm pregnant. And
but was it someone at the Louisville Police Department that advised you to call the Kentucky Bar Association?
Right.
Okay. Now, and so eventually you did get in contact with a lawyer and filed you filed a lawsuit. And did you pay the lawyer to file this? And so did you come up with the amount of money to put in the lawsuit to ask for?
No, I did not.
And so if you do obtain any money, what percentage will the lawyer get?
40%.
And you all moved away eventually from apartment 3.
Yes, we did.
So we have admitted
Exhibit 158 and 159.
Yes, they're both admitted.
That's all the questions I have.
Cross-examination?
Thank you, Your Honor. Ms. Napper, I just have a couple questions about the timeline here. You indicated that you and Cody went to bed about 10 o'clock,
Yes.
and do you know what time this all happened?
I would say right after 12:40.
And you indicated that it happened, it sounded like a bomb went off, correct?
Exactly.
And could you tell what that was?
After the fact, I mean, I jumped out of bed, I heard the noise, I learned that it was Iran with gunshots altogether.
Altogether, do you have any idea how long that lasted?
I have no idea.
I mean, was it a half hour? Was
No.
it a few seconds?
It was pretty short.
Okay. I think you described it at one time as sounding like Fort Knox, correct?
Exactly.
And that's what woke you up.
Yes.
Did you ever hear any conversation outside while that was going on?
No. I heard that and a neighbor crying.
Okay. And was the neighbor was crying after you heard that Fort Knox or heard the explosion,
Yes.
correct? How long was that afterwards, do you know?
I couldn't give you an exact minute by minute, but it was after the gunshots.
Okay. Your apartment is to the rear of the apartment where this shooting actually occurred, correct?
Yes.
It adjoins the sort of the back end of it?
It's right behind it.
Okay. Do you know what time the police, well, you said the police came and wouldn't let you out of the apartment, correct?
Well, the police were there from the beginning.
Well, but I mean, after this was over, you said you tried to leave the apartment and they wouldn't let you go, correct?
Not the first couple times, no.
And that was up near about sunrise, you said?
I mean, I wouldn't quote me, but it was well after 12:40 at midnight. I mean, after the shooting.
What time did you go up to the manager's apartment?
That was definitely daylight.
Was it morning, afternoon?
Morning. It was, I would say, not very early morning, but it was not afternoon.
Were the police still there at the apartment building?
Different ones were in and out all day.
Do you know what time did you see the last one, if you recall?
Oh, I couldn't tell you. There were so many different people there. I have no idea when the last time I saw one. There was an investigation going on for well into the next day.
Well into the next day? Okay, and you used the term scary and crazy. What did you mean by that?
I meant that I was scared for my life. I was scared for Cody's life. I was scared for my unborn child's life and my 5-year-old's life.
And this was right about the time this was all going on, correct?
What do you mean? Of course I was scared. There was gunshots flying through my apartment.
Well, and that's what I'm trying to determine is right at that moment is when it was pretty wild and crazy, scary and crazy.
It's been crazy ever since it happened. For 2 years now.
Okay, thank you. I have nothing further.
Anything else with this witness?
No, no.
You can step down, thank you.
Thank you.
The Commonwealth's next witness?
Commonwealth closes its case.
All right, thank you. Counsel, would you approach for a moment? Ladies and gentlemen, we're going to take about a 15-minute break, and then I will probably let you go home after that. I just need to talk with the lawyers for a few minutes so that I can give you some further instructions about tomorrow. So it's 10 till 5. Let's take a recess until 5 after 5. Remember the separation admonition.
All rise with the pledge of allegiance.
So my hope was that we would finish the case late in the afternoon and then bring the jury back the next morning, do instructions, closing arguments, send them out about lunchtime so that they'd have the entire afternoon. It looks like that plan's been thwarted a bit. So I don't have any idea how long Mr. Hankison's going to be on the witness stand. Can you at all ballpark what you think in terms of your direct?
Judge, I would think no more than an hour.
No more than an hour. Ms. Whaley or Mr. Finke, could you just ballpark? And I know that's a tough question, and I'm not going to hold you to it, but just to give me some idea. Would you? 45 minutes? So what is your all's thinking? Do you want to? We could have a short day tomorrow. I mean, we have the jury through Friday. We could have a short day tomorrow, have Mr. Hankison on the stand. We could talk about jury instructions after that. And then we could come back first thing Thursday morning, instruct the jury and do closings.
Would work for us, Judge.
Is that fine with you?
I agree with that.
Okay. All right. So I have a few things on in the morning in court. I think what I'll do is have the jury, instead of come back at 9:30 like we've been doing, have them come back at 10, and we can get started then. We may be able to wrap up by lunchtime.
Your Honor, I have a short motion for directed verdict.
Absolutely. I'm going to, well, we can probably go ahead and do that now. I was just going to say we'll do that after the jury comes back and I let them go, but we still have several minutes, so let me, okay, go ahead.
Your Honor, now that the Commonwealth has concluded its case, I think it's incumbent upon them to have established the basic elements of the crime of wanton endangerment. I'm going to read the statute. I know you're familiar with it, but the statute says a person is guilty of wanton endangerment in the first degree when under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. In order to understand what that statute means, you have to understand the definition of wantonly, which is also defined that's found in KRS 501.020 paragraph 4. And that definition states that a person acts wantonly with respect to a result or to a circumstance described by statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that circumstances exist. It then goes on to say the risk must be of such a nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. My first comment, Judge, is that I cannot fathom that the legislators who passed this statute back whenever it was enacted ever envisioned a time when it would be used to charge a on-duty police officer who returns fire at someone who has fired at him or his brother partner, and his bullets go astray. There's just no way that was ever the intention of the statute when it was enacted. I think it was more likely enacted to cover situations where somebody is walking down the street and they've got a gun in their possession. They say, let's see if it works, and they go off and shoot it wildly into a house, or for a drive-by shooting situation where a gun is fired at somebody and it misses and hits an occupied structure. That's what wanton endangerment is all about. It's not when a law enforcement officer is doing his duty. But more importantly than that, Judge, when you look at that definition of wantonly, it suggests that in order to be wanton, the actor must be aware of a substantial and unjustifiable risk that exists. He has to have actual knowledge of that risk, as opposed, it doesn't say must be aware of or should be aware of. It says he has to be aware of, which requires that he have actual knowledge of it. And then the actor must consciously disregard that known and substantial unjustifiable risk. Well, here the evidence is absolutely clear that neither Brett Hankison nor his fellow officers knew of the existence of apartment 3 behind apartment 4. So they did not know that they were not aware of any substantial and unjustifiable risk that exists. And beyond that, and Brett Hankison in his statement that was played the other day indicated that he thought they were at a fourplex, meaning he thought there were 2 apartments upstairs because of the 2 balconies, I assume, and two apartments downstairs because of the patios. He had no way, nor did any of the other officers, of knowing what was behind apartment 4. And as we just heard from Miles Cosgrove, and we've heard from other witnesses, there was never any diagram presented to these guys. They were all volunteers who just were sent out to serve this search warrant with no intimate knowledge of what they were getting into. So they were not aware of the substantial and the substantial risk that they were walking into. Secondly, I would submit that in order to consciously disregard a substantial or unjustifiable risk, you have to know it exists. You can't consciously disregard something that you have no way of knowing that it's out there. So that is that part of the wantonly definition that I think is applicable. But then you go to the other part of that definition of wantonly that says that the risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. And I think that leads into the justification statutes that are contained in KRS section 503, because the sections that must be viewed with reference to Chapter 503 would be Chapter 503.030, Chapter 503.040, Chapter 503.050. I'm sorry, I'm saying chapter, I mean section 503.070 and section 503.090. Every one of those is a different type of justification statute, any one of which I think applies to the conduct of Brett Hankison here. They all allow him or justify actions that are done to protect himself or others, which is clearly what the evidence here has established was happening. I would submit, Judge, that if you read those statutes in conjunction with 503.085, that renders Brett Hankison immune from criminal prosecution. That particular statute says if the conduct falls within these statutes, the actor is then immune from prosecution. And I would cite the court to the case of Commonwealth of Kentucky versus William Scott Albright, which is case number 2016 CA-001352-MR. That's an appeals court case that arose here in Jefferson County Circuit Court, and that deals with the immunity that's provided by Section 503.085. In short, Judge, I would submit that when you consider all of the evidence, the wanton endangerment statute, and add on top of that the justification statutes, the state has failed to meet its burden that it's required to meet up to this point in the trial. I don't believe the evidence even arises to the level of probable cause to believe that the offenses of wanton endangerment have been committed here. And for that reason, I would ask the court to grant a directed verdict at this time and take this case away from the jury.
All right, thank you. Ms. Whaley?
Commonwealth disagrees with the defense characterization of the evidence and more specifically the statutes cited from 503. Our position is the defendant is not entitled to any of the justification statutes. I don't think there's a single one in there that the defendant hasn't put forward, but 503.040, execution of public duties, 503.090, he is asked for use of physical force in law enforcement. That's actually limited to a defendant who is acting under official authority making an arrest. So that has no application here. Choice of evils, we disagree with that justification. More specifically, our position is he's not entitled to the justification under either self-defense or defense of another, because as KRS 503.120 subsection 2 states, when the defendant is justified under 503.050, any of the justifications, self-defense or defense of another, in using force upon or toward the person of another, but he wantonly or recklessly injures or creates risk of injury to innocent persons, justification afforded by those sections is unavailable in a prosecution for an offense involving wantonness or recklessness toward innocent persons, which includes wanton endangerment. And we would, when it comes time for the instructions, as we've already submitted the case of Commonwealth versus Cottle, 2018 Kentucky Supreme Court, where based on this statute 503.120 subsection 2, the defendant was not entitled to a justification instruction. The evidence has shown that the defendant, first of all, I'm not aware of any case, statute, rule, or otherwise that exempts police officers from committing crimes in the penal code. The wanton endangerment statute is no different than any other crime in the penal code. If a defendant, layperson, professional, police officer, or otherwise commits the acts described in the statute, then they are guilty. Firing blindly into the side of the apartment building, into the sliding doors, into the window covered by blinds and curtains, with no target, with no eyes on the threat, is, due to this particular defendant especially, and the amount of training that he's been through for the last 20 years, would obviously, particularly in light of Officer Bielhausen's testimony, the great extent to which the department goes to make sure officers know how to assess a threat, know what is a threat, know that it does require target identification, target isolation before a shot is fired. So the evidence has shown that he is aware of the risk to begin shooting blindly, and that he consciously disregarded that risk when he shot 10 times in the wrong direction into this apartment building. Now, as far as going, as counsel stated, he only thought there were 4. It's clear to anyone looking at the photos and anyone who has been there, there are 4 doors in the lower level facing you at the breezeway of that apartment building. There are 4 doors clearly marked, 1, 2, 3, and 4. In addition, there are 4 doors upstairs, 5, 6, 7, and 8. And in fact, as testimony established, this defendant had a personal interaction with an occupant upstairs who had come out of apartment 8. So it is certainly not Commonwealth's position that he full well knew there was an apartment straight ahead as you're standing in that breezeway with number 3 written on it, back to back, adjacent to apartment 4. For the reasons stated and under the law, as the court has established, that the Supreme Court has established that the trial court is to take the evidence in the light most favorable to the Commonwealth on motion for directed verdict. So we would ask that the court overrule the motion.
All right, thank you. And you did just state the rule, what the court needs to rely on in making the decision whether or not a motion for directed verdict of acquittal should be granted, and to draw all fair and reasonable inferences from the evidence and draw those in favor of the Commonwealth. If the evidence is sufficient to induce a reasonable juror to believe beyond a reasonable doubt that the defendant is guilty, a directed verdict should not be given. You know, when you look at the statute 503.120, under subsection 2, when the defendant is justified under the justification statutes that Mr. Matthews cited in using force upon or toward the person of another, but he wantonly or recklessly injures or creates a risk of injury to innocent persons. The justification afforded by those sections is unavailable in a prosecution for an offense involving wantonness or recklessness towards innocent persons. There's been no testimony that would cause this court to believe that Cody Etherton, Chelsea Napper, or their 5-year-old child constitute anything but innocent persons in this scenario that we have before us. The charge is wanton endangerment, so clearly it encompasses the theory of wantonness. You know, we just recently went to the scene. We saw how close together those apartments are. As you pointed out, Ms. Whaley, and as we've seen from photographs, the numbers are clearly on the doors of those apartments. The officers who went there that night, including Mr. Hankison, knew that this was an apartment building. No reason to believe it wasn't an occupied apartment building. In fact, every reason to believe it was an occupied apartment building, because they were there because of a search warrant for Breonna Taylor. So they certainly knew or expected apartment 4 to be occupied. And then, as has been pointed out through the testimony, someone came out of apartment 8 upstairs and had a conversation with Mr. Hankison. So it's 12:30 at night on a weeknight, clearly when you would expect people to be at home in their apartments. We've heard testimony from various officers regarding the shots that were fired, from agents from the FBI regarding the shots that were fired by Mr. Hankison, from the ballistics testing that showed that the bullets casings came from his gun. We've seen pictures of the shots that went through Cody and Chelsea's apartment, putting them in reasonable fear of serious physical injury or possibly even death as a result of what took place. In reading the statute, the justification statutes do not apply to Mr. Hankison's actions, and so this court will deny the motion for a directed verdict. All right, let's bring the jury. Is Anthony in here? We'll need to get the jury back in. Okay, if you'll bring them back in. Ladies and gentlemen, anything to report from the break? All right, so tomorrow we will gather together again to hear additional testimony in the case. We'll get back together tomorrow morning at 10. I have a few things on my docket between 9 and 10 that I do need to take care of tomorrow. You will hear, as I said, additional testimony. We will not, however, be doing closing arguments tomorrow. And I tell you that because you may want to plan for the day that we have closing arguments and you begin your deliberations, depending on how long you deliberate. And that's just totally up to you, how long it takes you to reach a unanimous decision. You could be here for a while or a very long while or a short while, depending on your ability to agree with one another. So we won't have closing arguments until Thursday. And that's the day that if you have children or pets, you might want to get someone to make sure that they're being cared for, just in case you should be here longer than the normal hours that we have had during this trial. But that will not take place tomorrow. Tomorrow we'll get back together at 10. I don't expect that tomorrow will be a very long day for us in court. So I hope you have a nice night. Please remember the separation admonition. I'll see you tomorrow morning at 10 o'clock.
All rise.